On 20th of this month.
I said you can't appear as part. How can you again?
Number 168 of 24. In this case, dismiss for non-prosecution. Later on, filing the recall application. Madam. This is a recall application is pending. Madam. Kindly posted. Madam.
Why should we, when you don't appear before the court and the matter is dismissed for default, there is no urgency. You file it, it will come on its own. It will be listed eventually. No, when the matters are listed, you don't appear, what to do? And this is not a formality. We'll dismiss it once. Again, you will file an application.
Sorry, my lord, because I engaged on another.
And whenever it is basing on the list, someday you add that. Yes.
My lord, serial number 26, my lord.
Mm.
It was dismissed for non-prosecution. NC petition was dismissed for non-prosecution. We had to file a miscellaneous appeal, my lord. Kindly permit me to withdraw and file a miscellaneous appeal, my lord.
Serial number.
Where is it?
Serial number
26, my lord.
Take that.
Liability fixed.
No, you realized it in 2025.
My lord, we received NOC 2 months back, my lord.
Then what will happen? Like right from 2024 till now, when was this petition filed? 2024?
My lord, it was dismissed on 1/3/23.
So probably you must have filed in the month of April.
Please.
So more than a year it is pending like here. And now you have to give
We have filed on 14/6, my lord.
And how the office can number this petition? They have to see which are appealable. They have given a list of what are the orders that have to be questioned and reverted. Against an order where the suit is dismissed for non-prosecution, the present writ petition is filed against the memo is filed that against the said order, the writ petition is not maintainable, and they'll convert the same into a MFA. And for that, and hence they were permitted to withdraw this petition with the liberty to file the necessary application. Accordingly, the writ petition dismissed as withdrawn, giving liberty to file a petition, to file an appropriate application, and the law of limitation and other aspects are left open for the court to consider. Yes, memo is taken on record.
Lord,
Please.
liability fixed on the owner, my lord.
Huh?
Liability fixed on the owner, my lord. Can you please fix any date for hearing, my lord?
Which year is that?
23.
It will be give to the court officer. Someday it will come.
My lord, serial number 29, my lord.
29. Yes.
My lord, today matter is listed in the family court for the hearing of maintenance itself. So accordingly, I'll seek instruction from the client and seeking adjournment for 1 week, my lord.
No, this writ petition is filed in the year 25.
Yes, my lord. It's in the hearing is in the family court, my lord.
No, I understand. What is this writ petition for?
This is for the DV. In the DV case, the interim order was been passed for the maintenance, without hearing the petitioner. So on that, we have challenged that order, my lord.
Order passed in the DVC.
Yes, my lord.
In a writ petition.
Yes, my lord. Today the matter is in family
No,
court.
please wait. Something of the facts which you are stating, I think there is some connection is missing. We'll see when the matter reaches, then we will adjourn the matter. Yes.
Page number 734.
Yes.
Serial number 21, my Lakshmi. A short accommodation senior will appear in that matter, my Lakshmi.
21, page number 5.
Serial number 21, my Lakshmi. list one.
Telangana A.
There's a delay of 782 days.
Senior will appear, my lord. He has gone out of
He'll
station.
ask him to appear. How many times this matter will? I remember this matter. Last occasion I've asked, what is this delay of 782 days? Is it the case?
No, this is not the case, my lord.
Then what is that case?
Like last time, there was a notice was issued to the respondent.
It is no respondent is, notice to respondent is held sufficient. This is matter tomorrow, no further adjournments. Yes.
Page number 7, 34, page number 8.
Serial number 30, your lordships.
Hmm.
I
Page
pray for
number
1 week's
9.
accommodation. My senior is sick. The notice is yet to be given to the respondent. It's served. It's in transition of being served, sorry. 30, serial number
Finally, a
30.
week's time, no further time will be granted.
Yes.
My
Yes.
lords, serial number 50, my lords,
Let her call that page.
Page number 9, serial number 37 to 41. Page number 10, 42 to 51. Page number.
serial number 50, my lords. The instructed counsel could not be present today due to personal inconvenience, my lords. So we seek for a short adjournment, my lords.
You appear for the petitioner.
Petitioner, my lords.
What about the respondent?
Will inform.
No, will inform. You have to inform or else you have to wait till the matter is called. Yes.
Serial number 51, my lord. I appear for the respondent. Seek 2 weeks adjournment, my lord.
Why?
Senior is out of station.
Huh?
Senior is out of station.
For 2 weeks. You appear for the petitioner or the respondent?
Respondent, my lord.
For the petitioners in that matter. ma'am.
You also have no objection.
They have informed us yesterday itself, they saying that he's not in town.
This is matter next week, no further adjournments.
A date may be fixed, Manoj. We have
Next
no
week, a
objection.
date they will give. Yes.
Great.
20th, my
Serial
lord.
number.
Basing on the court's,
Convenience.
board that will be given. Yes.
Page number 11, serial number 52 to 58. Page number 12, 59 to 63.
Serial number 60, your lordships. 1 week's time.
Have you
For the
informed other
petitioner,
side?
the respondent has not yet filed wakalat.
Madhu or
It's written, wakalat not filed. We have served him hand summons, your lordships. We filed a memo to the same. They have still not filed wakalat.
Madhu or is
The,
Madhu Yadav.
yes,
again,
Madhu Yadav.
We will see. And we don't know what is their urgency. At that time, we will be granted.
Serial number.
No, adjournment will be granted. We have to hear them and then we'll grant adjournment. Please wait. Yes.
Page number 13, serial number 64 to 67. Page number 14, 68, 69. What?
The 68, 69, please inform them it is not possible at 2 o'clock. It will be taken up at 5 o'clock.
My lord, 2020 MC case, my lord, for speedy disposal.
Huh?
For speedy disposal.
Which court is that?
2025.
Which court?
Court, order passed.
Speedy disposal, which court it is pending?
No, I have filed for the speedy disposal of the crime.
Matter pending before which court?
Bangalore family court.
Hmm?
Bangalore family.
Bangalore Family Court 20, now no urgency, will not pass any order. Yes.
Great.
Case number 1, serial number 1, Mohan BK.
For petitioner, my lords.
Yeah, for respondent.
Yes.
Lords, in this case, what had happened is, my lord, the respondent wife had filed a maintenance petition before the family court, my lord.
Hmm.
I would like to take your lordship to page number 33, my lords.
Hmm.
The matter was posted for appearance of the respondent, my lord, on 8/1/25.
Hmm.
On that day, the respondent therein, there is a petition herein, he appears and he says that he is ready to take the petitioner with him.
Hmm.
Thereafter, the matter got adjourned to 24/1/25, my lords. On that day, because my mother had fallen sick, I could not appear before the court.
No. Already you are not present on 24/1/2025.
Yes,
You were
madam.
not present on 6/2/2025. You were again not present on 14/2/2025.
Yes, I will come to that, my lord. The first of my appearance was on 8/1/25, where I appeared and I told the court that I am ready to take back my wife, my lord. Then the matter got posted
Yes.
to 24/1/25. In the intervening period, my mother falls sick, my lord. She need to be operated.
When your mother falls sick.
My lord,
No,
on-
if your mother falls sick, your counsel must be there.
No, my lord, I had not engaged the counsel then, my lord. I directly appeared on that day saying to the court, I am ready to take back my wife. I did not wanted to contest the petition, my lord. So the matter got adjourned to 24/1, and in the meantime, on 21/25, your lordship would find at page 37, my lord, the medical where my mother was operated for right diabetic foot. I'm the only son to take care. My father is not there, my lord.
What is the date? Just like that one, it is on 21/20/25.
Yes, my lord. There afterwards, for 1 month, I had taken care, my lord, and the whole of the family court matter got disposed within a span of only 1 month, my lord. Your lordship would see that on 24/1/25.
Those are the directions to the family court. IA has to be disposed of within a week, within a month.
I'm ready, my lord. I'm ready to cooperate with the family court in speedy disposal, my
All
lord.
these reasons, like my mother is not well. If your mother is not well, after that, can't you, if you either you have to engage an advocate, go to the court. For 2 months, you can't keep quiet.
It was not 2 months, my lord. In a span of 1 month, I appeared, engaged an advocate, and he tells me that the matter has already been disposed, my lord.
The order is on 25/2.
Yes,
You appeared on 81.
Yes, ma'am. On 14/2, the matter was posted for judgment, and on 25/2.
25/2/2025 is the order.
Yes, my lord. My mother was operated on 21, my lord. In a span of nearly 1 month, my lord, the entire process got over, my lord. Because it is a family matter, the family court should have been little bit slower so the parties can be.
No. Family court cannot be slow.
My lord, when I had expressed the intention that I want. No, my lord, when I had expressed the intention that I want to take back my wife, I did not want it to contest. So in the meantime, I need to give importance to my mother because I'm the only person who am taking care of, my lord. Apart from me, there is nobody because my wife has.
20,000 is granted.
No, well, I have already. I'm unemployed, my lords. Your lordship would see at page 49, my lord.
When was the order passed?
It was passed on 24/2, my lords. 24/2, my lords.
When did you come to this court?
My lord, on 1st of July, my lord.
How much delay?
20 days, my lords.
So at every step you want indulgence of the court.
No, my lord, it is only for my mother because other than.
Please note in all that. If your mother is not well, she is that you're not doing anything. You will be doing other things also. Except
no, I have my job also to take care of my mother, my lord.
Not round the clock, you will not be sitting with her.
No, as of now, she wanted my attention. That is my lord. It's only a temporary arrangement, my lord. So I may be.
The court can only, because for all your fault. Now the court has spent time on this case and granted 20,000. I can only set aside this order and remand it, provided you pay 10,000.
Great.
Otherwise,
10,000, including both the wife and son, my lord. Because wife is also working, I had no opportunity to put forth.
Please come to the order.
20,000 plus 6,000, my lords.
Per month to the petitioner number 1.
Yes, my lord.
Pay maintenance of 6,000 per month to the petitioner number 2. You will remain smarter.
My lord, kindly see my page number, my lord, para number 15 of the trial court judgment, page number 22.
Yes.
My lord, the petitioner is having produced the exhibit P13 and 14, which is about that the respondent is working as a company for software company as annual pay of rupees 16 lakhs. My lord, I have filed my affidavit and assessment of liabilities before the trial court. My lord, he not filed any objection. He himself appeared before the court.
That is what I understood from that he has not filed, he has not contested. Where is the evidence to show what is the income of the husband?
My lord, I have produced the, my lord, the exhibit, my lord, he has chartered certificate, he is software, he is working in L&T company before that. Thereafter, he has joined, my lord, in guest software company, my lord.
You file an affidavit before the court that you are unemployed. From when you are unemployed, then we will see. Mr. Mohan.
Hello.
Please file an affidavit before the court stating that you are unemployed.
From 17.
What were you doing? From how long you are unemployed? If you are working earlier.
Yes, my lord.
Where are you working?
Yes, ma'am. I'll file an affidavit because right now I'm depending on the rent income of 15,000 rupees, where I have partially let out my property, my lord, in the basement, my lord, for commercial purpose.
When you're working in a software company, why did you quit?
No, because only to take care of my mother. It was only a temporary arrangement till I make some alternative arrangement, my lord. It's not that perpetually I'll be keep sitting at home, my lord. Only because I need money to get my mother also treated.
Of taking care of the mother, you have quit the job where you are getting what is the salary?
Is 16 lakhs per annum, my lord.
No, my lord, it's only 60,000. 60,000 per month. That is what I was getting, my lord.
So you will quit a job of 60,000, sit at home and take care of your
No,
mother.
it is only a temporary remedy till my mother became all right, my lord. Now I am searching. It's not that perpetually I'll be sitting at home, my lord. Now I'm searching and I'll be getting into the job. Till then, I may be given a till then,
Absolutely no bona fides on the part of your
my
client.
lord, till then I may be given a temporary respite as such, my lord, because there is absolutely no
He
income.
is receiving my lord, rent from the my lord, complex, my lord.
Then
My
counsel
lord,
for
as-
the petitioner shall place before this court an affidavit about his occupation. Earlier, it is a submission that he is unemployed. Earlier, where he is working, what was his last drawn salary? All these details shall be placed before this court. Yes, list this matter on Friday.
Please.
Madam, I may be given a 1 week time, my lords. 1 week time, my lords.
Yes, Wednesday.
But my lords, in the meantime, the trial court is, my lord, they are
And also, my
issuing
lord,
warrant, my lord. My lord,
only
in
30
case they arrest me, my lord, there will be nobody to take care of my mother, my lord.
There is arrears of 3
Don't
lakhs
tell that
42,000.
all the time. 20,
My lord,
yes.
the matter is posted today before the trial court, my lord. The stage is for issue of enbrochure, my
Go
lord. I may be given 1 week's time, my lord. The stay may be given only for a week, my lord.
Dhananjay Kumar. Cell number 2, Dhananjay Kumar for petitioner. Udesh Kumar
Hearing for the
Acharya.
petitioner.
Yesterday I heard this matter. Yes, please come. The present RPFC is filed. Agreed with the order passed by the family court. Which page is the order?
Page number 8, Your Lordship.
Agreed with the orders passed by the family court dated 16th October 2021, whereby the family court had granted maintenance of an amount of rupees 10,000 per month to the wife from the date of petition till to the son. Who is the petitioner?
Son, my lord.
Son,
To
Your
the
Lordship.
son from the date of petition till the completion of his education or till he become financially independent, whichever is earlier. That order is assigned by before this court in this RPFC, which is filed in the year 2023. The petition is filed with an IA to condone the delay of 319 days in filing the petition. In support of the said IA, an affidavit is filed. In the affidavit, it is stated that the petitioner husband has challenged the order dated 16/10/2021. It is the case of the husband that wife herself withdrew from the company of the husband and shown cruelty towards him. Because of the cruelty meted out by the wife, he has to file MC number 1654 of 2013 for seeking dissolution of marriage. At that point of time, this petition under 125 CRPC came to be filed. And the court has granted 10,000 maintenance. It is stated that he has paid the permanent alimony to the wife as per the order passed by the family court in MC number 54 of 2013, and there is no due from his side. He was attending the execution case before the trial court, which is filed by the wife, seeking execution of the filed by the son, seeking execution of the impugned order. It is stated that due to the ill health and financial position, he could not able to contact the advocate at Bangalore to prefer an appeal. Hence, there is a delay of 319 days in filing the RPFC. When counsel appearing for the petitioner submits that because of the health reasons of the petitioner, husband, he could not file the revision on time. Considering the same, the delay may be condoned, and the delay may be condoned, and the matter may be heard on the merits of it. Learned counsel appearing for the respondent submits that the respondent has failed to give cogent reasons for the delay, and no grounds are made out to condone the delay of 319 days. Hence, the application, the IA 1 of 23, has to be dismissed. Next one. Having heard the counsels on either side, peruse the material on record. When an application is filed seeking to condone the delay, particularly when there is an inordinate delay, the party has to explain the reason for such delay. In this case, except saying that he is not able to contact the advocate, is suffering from ill health, nothing has been placed on record to show that there are genuine reasons for such delay. When after the order is passed, execution is filed. When he was contesting the execution, according to his own affidavit, at that point of time, he was not aggrieved with the order. Why he has taken a decision to file an appeal at a later point, or revision at a later point of time, and why at the earliest point of time could not be filed, except the reason of ill health and not able to contact the advocate. No other convincing reasons are forthcoming. The courts cannot condone the delay as a matter of right, and in the considered opinion of the court, no grounds are made out accordingly. I number 1 of 23 is dismissed as no grounds are made out. Consequently, RPFC is dismissed.
Cell number 3. The end for petitioner CH-18 Kumar.
Petitioner Lordship.
Very simple order. Impugned order. Page number. What is the amount granted?
10,000, my Lordship. It was
10,000 to the wife.
the wife
And
by the lower court, Your Honor.
The wife and
For all three belongs, in the sense, 2 children, wife.
2 children and wife.
Yes.
And
What is the age
apart
of the
from the educational expenses, Your Honor.
What is the age of the children?
Because now the first child is around 17,
17.
17, and the second is around 13.
13.
Yes.
Father is taking care of the educational expenses.
Because the
Yes,
education
Your Honor.
expenses, after we filed the application, he volunteered. He's paying the education expenses
Of both the children.
of both the children.
So apart from that, this 10,000 is granted.
Yes.
What are the educational expenses of the children?
Minutes, the fee is already placed before my lords. 40,000 minutes. In
Per
fact, the
each?
school fees.
No, Your Lordship. 80,000 per year per child.
No. That is a wrong statement. In fact, they have placed the payment made. It's at page number 55, Annex G, that they have
Page
filed.
number?
55.
If you have, you can also show my counsel.
Yes. Their petition, for a child, they are paying around 34,000 minutes.
No.
That was for
It is it's probably a half yearly, basing on
Yes.
that, because as a mother, she must be knowing it. What is the fees?
Let me submit, Your Honor. What happened was, we were voluntarily going to the school and we were paying the fees. Later stage, what they said is, give the amount to us, we will pay. So now that the present scenario is, he will give the amount to them, they will pay, and we are not getting in turn any receipt as such. So they should only tell us what exactly the amount per child. Now I understand that for the younger child, the amount is already been paid.
It is 40,000 minutes. She is here
40,000 for each
per
child.
child. Yes.
So 40, 80,000.
80,000. That is what he is paying.
No, the elder one supposed to be clearing the SSLC. I think he's not cleared the SSLC. So now he has to pursue the PUC. I'm not sure whether he's pursuing the PUC or is still at home. I'm not sure about that because we don't get any details in respect of educational status as such, Your Honor.
They are paying
We only
directly.
give the amount and they pay the amount.
Paying directly. What is admitted?
We are not
minutes?
paying
In fact-
directly, Your Honor.
In fact, the affidavit.
Fees. Yes. Please, what is the salary of the husband?
30,000 was affidavit was filed, probably in the span of 3-4 years, probably, I'm not sure of the current salary, probably I can take on record the next submission. I've not taken the information as such, Your Honor. The latest salary. When we filed the affidavit, it was 30,000. He works in FSL.
Please get instructions.
If I
We'll
may
pass
make a
over this.
submission,
Sure,
Milord,
sure.
may I just make a submission, Milord? In my affidavit itself, I specifically stated the fees is around 40,000 plus 40,000. That is
Not about the fees, about his present salary.
I'll take a information.
You want it today or tomorrow?
Probably next week, probably I can come along with a salary slip as well. The
You also
latest.
have any other things?
Sure.
Please place on record.
Next
This is
week,
matter
probably.
on Tuesday, under the same caption.
Much obliged.
Yes, 4. Yes,
Cell number 4. Shankar MN for petitioner.
yes. Yes,
Because yesterday, you had asked me to produce few materials which was produced before trial court, I mean family court.
take that. You are seeking enhancement
Yes, Milord.
and court had granted 20,000.
20,000.
And according to you, what is the salary of the husband?
Because at that point of time, it was 40,000 Milords. 40,000.
Hmm.
Apparently,
So-
according to my knowledge and as per what I have stated in the assets and liabilities, he earns much more than 3 lakh rupees Milords.
So problem is, it is not your assertion, there should be some document in support of that. When he is earning 40,000, court has already granted 20,000.
Yes.
Where from he will pay 2 lakhs?
Because he's only like, he's given a salary certificate which says 40,000
One
Milords.
house number so and so,
Yes.
the consisting ground floor
And he's
second
deriving
floor,
rents from all those properties Milords. And agricultural property as well.
commercial and residential building.
And before the
1 lakh.
learned family court
Then
Milords.
how did the family court dealt with this particular aspect? Come to the order.
Yes, sure.
Start reading from paragraph number 14. What is your qualification?
BA Milords.
What are you doing?
I'm an unemployed housewife Milord.
What is the age?
Age probably 30 years Milord.
Further, she had disclosed that she is getting rental income of 25,000 from her parents' side joint family property.
Yes, Milord.
So she has income of 25,000 per month.
Yes,
Court has granted 20,000.
Yes, Milord.
Now it is 45,000.
Yes, Milord.
What are your expenses? Let's see.
Let's kindly see para number 8.
You have a daughter aged 6 years.
Yes, Milord.
Expenses of the child 15,000. She says she requests 4,70,000 towards the maintenance of the child.
Milord, that's may I know which is this?
E. That is E, details of children of the parties. You have passed on this. In that you have page number 4. Only education she requires 4,70,000. Towards food 15,000 for the child. 10,000 for extra activities. All exorbitant figures.
Let's kindly see the annexure attached to the judicial minutes. The school fees itself is around 2 lakh rupees per year. It's for grade 2A, Milord. And the father himself, he has admitted the child to that particular school, my lords. He has paid the school fees in the year 2022 and 23 for the academic year.
You says particulars of the occupation income of the spouse, founder of Sri Vinayaka Vidya Institute, Bangalore, 3 lakhs per month. Where are your other expenses? Read para number 15.
15 of?
Of the impugned order.
On the other hand, respondent had produced certified copy of his appointment order whereby he has been appointed as teacher to the government college. So the document produced makes out that he is an employee of Sri Vinayaka Educational Society. So if at all the above school is run by the petitioner's father, then there is no reason for the petitioner to work as an employee in said college. He had also produced his identity proof to make out he is an employee. He is employed at pre-university education in VS Krishna Iyer Composite Pre-University Education in VS Krishna Iyer Composite.
The present petition is filed by the wife seeking enhancement of the maintenance. In the statement of assets and liabilities, she has given particulars of properties husband is owning and what is the rental income from the said property. In the order impugned, the court had not discussed anything with regard to those properties and what is the income that is derived from the said properties, and given an amount of rupees 20,000 as maintenance. The present petition is filed seeking enhancement of the maintenance. The petitioner is permitted to take out notice to the respondent and shall place before this court. The memo shall be filed. He shall take out the hand summons on the counsel appearing for the respondent and file a memo to the defect by 28th of August, or else the writ petition shall stand dismissed. Delete from part third.
Serial number 5 for dismissal matters. Serial number 5, Harini Shivanand, for petitioner, Raghu KB.
The matter came up on 21/7/2025 as there is no representation on behalf of both the parties. The matter is directed to be listed today under the caption dismissal. Today also, there is no representation. It appears that the petitioner is not interested to pursue the matter. Accordingly, dismissed for non-prosecution.
Serial number 6, Rupesh Kumar S for petitioner. Shekhar PA.
Yes.
Wife's
Who
petition,
appears
my
for the
lord.
wife? Who appears for
I
the
appear for the wife.
You appear for the wife. Wife is seeking an enhancement.
Yes, yes, ma'am.
Please come to the impugned order.
And the impugned order is at page number 13, ma'am.
How much is granted?
The operative portion is at page number 34, my lord. To the wife, my lord, 8,000 and 5,000 each for the two minor daughters, ma'am.
So 8,000 plus 10,000.
Yes.
18,000.
Yes.
How much is sought?
It's at 20,000 each for the minor kids, my lord.
20,000 each. That is for her wife. How much it was?
So for wife, my lord, it was 15,000.
So total, what is asked for is 55,000.
Yes.
What is the income of the husband?
Lord, he is into business, my lord. And he is also a sales executive, my lord. Sales executive. And that has been admitted, my lord, by him at page number.
Correct. What is the evidence on record about his income?
Lord, at page number 19, my lord. The respondent contended, sorry, 31, my lord, paragraph number.
Let's
20.
read from para 13.
Para 30, page 31, my lord, para 22.
No, let's read from para 13. I'm saying.
Allowed on 30. Next week, my lord, kindly out on next week. Senior in
Why?
Senior not in station.
No, we'll decide it. Yes. Read para 13. Because it doesn't make any difference if your senior is there or you're there. You can assist the court. Yes.
The respondent denied case of petitioner number 1 and contended that the petitioner number 1 has made false allegation against respondent for the purpose to get relief from this court. In fact, the respondent never ill-treated petitioner number 1 in any manner, and he was looking after the petitioner number 1 and their family with love and affection and was spending his entire income for welfare of the family. The petitioner number 1 and respondent were together till March 2022. Meanwhile, in 2019, the respondent commenced his own business by availing loan of rupees 11 lakhs from HDFC Bank. But due to COVID pandemic, he suffered loss in business and could not repay loan. Later, in order to pay HDFC Bank loan, the respondent borrowed land loan from others and he was in financial crisis. During this period, the petitioner number 1 joined with Infotech company for job. The attitude of petitioner number 1 towards respondent suddenly changed for the reason best known to her in March 2022 and filed this petition when respondent was living with petitioners. Thereafter, the mother of the petitioner number 1 asked respondent to vacate the house. In fact, the respondent has not committed any mistake. The petitioner number 1 filed this petition on false ground. The respondent is facing financial problems and he has availed loan and financial institutions from financial institutions. The respondent requires to maintain his aged parents and repay loan of rupees 9 lakhs. Now the respondent is not able to repay the loan. Therefore, the petition filed by the petitioners be dismissed. So this is the contention, my lord. And the finding on
To understand what are the contentions.
Yes. To prove her case, petitioner number 1 deposed as PW1 in support of petition governments and relied upon documents.
So now there is a house
Yes, ma'am.
gifted by the mother where the wife is staying.
Yes, ma'am.
What is the occupation of the wife?
Wife, my lord, she is a TV anchor, my lord, and a serial actress. And it is not a regular job. Whenever she is called, she will go.
So according to her, like on an average, how much is her income per month?
Per month, maximum 5,000, my lord. Once or twice, they'll be called. It will be half an hour or 15-minute show, my lord.
No, in her statement of assets and liabilities, she must have stated what is her occasional income.
15,000 she has stated, maximum, and that is also seasonal, and it is not on regular basis. And there is also another allegation that the petitioner was working, my lord, at Vidvat Infotech company and earning salary of more than 30,000.
How many works he will do? Working in a company
She is
for
not working there,
30,000.
She has quit that job and subsequently she was doing this anchoring. Paragraph number 22, my lords, page 31.
Where is a discussion about his financial position?
31, page 22.
Paragraph number?
22, madam.
That I have seen.
Yes.
No, where do you find that? How is it quantified? How is it stated? What is the income? Except saying that he is doing business.
At paragraph number 26, my lord.
Yes.
As far as quantum of maintenance claimed by petitioner is concerned, the facts and circumstances of the case show that the maintenance claimed by petitioner, that is rupees 20,000 each per month, is excessive.
Yes.
The respondent has contended that he has suffered loss in business and is facing financial crisis, and he requires to pay loan and is searching for job. The fact that the respondent was running business is an admitted fact. The respondent has admitted during cross-examination that he owns 2 motorcycles, one purchased in 2022, and goods vehicle and car. So he has purchased goods vehicle and car for his business purposes. This being the fact, the respondent requires to prove that he lost business. But the respondent has not produced any evidence to prove that he lost business. Hence, it is a point that there is no valid reasons to accept case of the respondent that he lost business. The contention of
For doing the business, he has taken loan. For doing the business, he has taken loan. For that, he has purchased the car.
Loan is also in the name of the petitioner, my lord.
Wife.
Yes, madam.
Who is repaying it? Husband is repaying it.
Yes, madam.
How much he has to pay per
Like,
month?
defaulted in making that payment.
So that shows that he is not having in.
Voluntarily done that, madam, so that the petitioner could pay the
Because
amount.
unfortunately, there is no evidence before the court even to grant this amount.
No, he has admitted, my lord, he is owning.
We'll set
his own
aside this order. We'll set aside this order. Let the court decide.
Lord,
We can't, first of all, what is granted itself is on the higher side without any evidence.
no. It could be
Question of
remanded,
allowing
madam.
your petition does not arise.
It could be remanded, madam. Let
Yes.
the trial court decide it fresh. And there is
Agreed.
also, they're divorced, my lord.
Huh?
They're divorced now.
When was the divorce?
2022, madam.
20, after this order?
No, on the same day of the passing of
Oh,
this order.
same,
Same
No permanent alimony is not
permanent
granted.
element.
Agreed with orders passed in. Criminal miscellaneous number 637 of 2022 dated 30th September 2023. What is that? No, not required. Whereby the court had granted maintenance of 8,000 to the wife and 5,000 each to both the children, and 10,000 to his litigation expenses. Both the wife and husband are before this court. The wife has filed RPFC number 117 of 2024 seeking enhancement of the maintenance, and the husband had filed RPFC number 259 of 2023 seeking questioning the order of maintenance. It's a case of the wife that she's a TV anchor, but regularly she is not having the work on and off. She's getting, and from that she has 15,000 income. Her mother has gifted a house in that she is residing. The husband is doing business, is having good income, but he failed to maintain the wife and the children. Next part. It's a case of the husband that he has taken loan for doing the business of an amount of 11 lakhs during the COVID time, and he has sustained huge losses. Now he is not even in a position to pay the EMI. He has to take care of his parents. And as stated with the wife, the amounts that he is doing a business and having income is without any basis. The court, by order impugned, had granted the maintenance considering the contentions. And while granting the maintenance, the court observes that the husband has contended that he has suffered loss in business and is facing financial crisis and requires to repay the loan and is searching for a job. The fact that the respondent was running business is an admitted fact. The respondent means the husband. The husband has admitted during cross-examination that he owns two motorcycles, one purchased in 2022, a goods vehicle and a car. This being the fact, the husband requires to prove that he lost business. But the husband has not produced any evidence to prove that he lost business. And hence, the court came to the conclusion that he has the financial capacity and he can pay the maintenance and granted the same. Next part, when counsel appearing for the wife submits that when the husband is doing business, having sufficient income, the court ought to have granted the maintenance as sought, that is 45,000 per month. With the maintenance that is granted, it's difficult for the wife to take care of herself and the children. All these aspects were not properly considered by the court. As such, the petition needs to be allowed by enhancing the maintenance. Next para. Learned counsel appearing for the respondent husband submits that the court, without considering the fact that the husband has sustained losses and he is not in a position to pay the amount, just basing on the fact that a car and a goods vehicle were purchased by the petitioner, by the husband, the court had, without any basis, has granted the amount. It is submitted that the husband has no financial capacity to pay the amount. Next para. Having heard the counsels on either side, peruse the material on record. The wife has come to the court seeking maintenance of an amount of rupees 45,000, and that the husband is doing the business, except the self-serving statement. No evidence is placed on record. As for the judgment of the Honorable Apex Court in Rashish versus Neha, both the parties are supposed to file their statement of assets and liabilities. And what are the documents that have to be filed in support of their statement of assets and liabilities? Liabilities are clearly enumerated in the judgment. Once, if all those documents are placed before the court, as per the judgment, the facts would be crystal clear, and basing on that, the court would pass orders. After the judgment of the apex court, there is nothing much left for the court to do the guesswork. In this case, except looking at a vehicle that's purchased in 2022, the court has not given any finding with regard to the financial capacity of the husband. When once the financial capacity of the husband is not known, this court cannot pass any order granting a particular amount or enhancing a particular amount as maintenance. In the considered opinion of this court, the matter needs to be remanded to the court. Accordingly, this court is passing the following order. Number one, the order dated so and so, passed by so and so, is set aside, and the matter is remanded back to the trial court, back to the family court, and the family court. Number two, both the parties shall file their fresh statement of assets and liabilities before the court.
Need further evidence if any.
Before the court, and the court shall consider this application provided both the parties place before the court their respective statement of assets and liabilities as per the judgment of Rashish versus Neha. Third, both the parties are at liberty to adduce further evidence if necessary. Well, how much is the amount you are paying? Any interim order in this?
Entire area paid. 18,000.
Huh?
18. There was no stay.
No stay. Till the application is decided, the husband shall continue to pay the very same amount. That is an amount of rupees 18,000.
Action to dispose of the matter within 6 months.
Which year is this?
2022.
Yes. Same, both the petitions are arising out of the same order. Yes, next.
Cell number 7.
Anand Mustafa. Petitioner in this matter, Your Honor. Apologies on the last occasion we missed it. Didn't come to a notice that the matter was listed.
Yes. Where is the impugned order?
Your Lordship,
Lord, one submission. I'm not having file because yesterday when I saw the list, it was not listed.
Petition is of the year 2022. When did you file the wakalat? Because there is no purpose of keeping an IA pending.
Yes. No, I'm not.
and it's a fairly simple
And
matter, Your
moreover,
Honor.
my
We are not
lord-
asking for a stay of the
The
petition.
GNWC of,
A stay was only for a particular day only because.
what is that impugned order, let's see?
The impugned order is for directing the child to be kept present in the court. The background to that, Your Honor, there is a GNWC.
Let me look at the order first. Where is the impugned order?
The impugned order is on page number 27, Your Lordship.
27. The
Yes.
respondent is restrained from taking the child.
Your Lordship, the daily order, the order sheet, which
Oh.
directs the party to keep the child present in the court as a last chance on.
Where is that? Page number.
Page number 20.
But it is date of the order. You have the.
The date of the order is as on 17/10/2022. The background of the case is, Your Honor, we have filed.
Let me look at the order
Most
first. Where
obliged.
is that 1710?
Page number.
27, page
Advocate
number
for
27.
petitioner filed application with memorandum of facts seeking for the appointment of psychiatrist for evaluation of the mental condition of the child. Advocate respondent filed FS so and so for evidence of
The
petitioner
next
and directed to keep the child present before the court to enable the respondent to avail visitation rights to the child by 17/10/2022.
On 1710, another order was passed directing the
Advocate for
child.
petitioner time for compliance of the orders reporting that the child is not keeping well. Respondent and counsel are present and oppose adjournments. Peruse the records. On previous date of hearing, advocate failed to comply and keep the petition. Why should you question this order?
That's the background. The background is that we filed a GNWC. They have filed an application for custody. We have filed objection to that application. The trial court, instead of hearing on that application, directs the child to be kept present. On one occasion, we keep the child present. Your Honor may kindly come to page number 43. These are the pictures which we have annexed along with the petition. A brutal attack made on the mother with a fish bowl, where she has 15 stitches on her head. 15 stitches on her head. She is in a pool of blood. 7-year-old child has witnessed this. She is bawling her hats off, and she is secured with great difficulty with the help of the neighbors, because the father was even in that situation, he was restricting the mother from seeking help. Subsequently, there is a criminal case filed, charge sheet has been filed, the trial is ongoing. Without considering any of these facts, the trial court calls the child in a packed court hall, directs her to interact with father in the presence of the court. And most brutally, when the child clings on to the mother and refuses to look at the father also, the trial court is shouting at the child saying, look at your father. This is your father, who is standing next to you. The child is kept traumatized in the court whole day. None of this is recorded even in the order sheet. We make a repeated request to the judge to at least record the presence of the child in the court on that day, her refusal to interact with the father, and let go of the child at least by noon. She is kept present in the court whole day. And another order is subsequently passed without recording any of this. That child should be again kept present. We said, please hear the application. Please pass an order on the merits, taking all these submissions into consideration.
So you have a stay in this petition.
So there was a stay on the order of the trial court to keep the child present. That's all we have asked. Please don't pass orders.
What is the stage of the GNWC now?
Stage is still in the petitioner's evidence, Your Honor. We are happy to conduct the trial.
Which year is this GNWC?
This is 2019, and then subsequently.
Which code is this?
It was third additional.
We'll direct them to dispose of the GNWC itself.
My lord,
By December
one submission is that they obtained the stay from this honorable court only for the particular day on which the honorable family court has directed the petitioner mother to keep the child present before the family court, my lord. Whatever my learned friend has submitted, making allegation against the court, stating that she has kept the child present. It all false submissions before this honorable court, my lord. And you lords may kindly say, till today, my lord, several oral orders has been passed, directed the petitioner to keep the child present. And,
so what
and one more.
What exactly you want to do? Forever now the child would be remembering what has happened at the age of 7 till his 100 years, the child, like whatever he becomes a senior citizen, till such time, he will be only remembering what has happened to the mother while he was at the age of 7. You will not do anything. You will not take him to a doctor. You will not make any kind of efforts to see that something is done.
The child is undergoing counseling.
No, you will also make one more important submission. Sorry.
During the course of this, since it was a COVID.
I'll post this matter on Tuesday. By the time you shall place entire record before this court from 2022 till 2025. To which doctors she has taken him for counseling, how periodically the counseling was given to the child, all the record.
I shall ascertain.
My lord, I wanted to make one submission. They produced the doctor certificate stating that he is a psychiatric doctor and all. He is not a psychiatric doctor, he is an eye specialist. And that doctor he was my client, because I know very well that And they produce all such wrong certificates before the court.
Is filed, questioning an order of the court, where the court had observed that the mother shall keep the child present before the court and uh, as a last opportunity for the father to have the interaction with the child. It is a contention of the learned counsel for the mother that the father has assaulted the mother earlier and the child was a witness to that. As such, the child is not interested to see the father. On the earlier occasion, before this impugned order is passed, the child was present and the child was not even looking at the father. And the child, the judge shouted at the child and asked her to talk to the father, which was declined by the child. All these things were not recorded by the learned judge, and again this order passed, which made them to come to this court. First of all, making all these allegations on the judge without even asking them to record or filing an appropriate application, and which is not on record, the court will understand what transpires in the court basing on the order that is passed by the judge. And apart from that, there is no other way the court will understand what has transpired in the court. Then this petition is filed in the year 2019. We are in 2025. Admittedly, the child has not met the father from 19 to 2025. The reasons that are stated is she is a witness. If she is a witness to a particular incident which has happened when the girl is 7 years old, and if the mother wants to keep those feelings and emotions live and to continue the hatred against the father, definitely it is not in the interest of the child. According to the learned counsel, the child is taken to the counselor. This court would like to know, right from 2022, from the date the order is passed by the family court till now, what are the steps taken by the mother for getting the child out of these kind of negative emotions which are not in the welfare of the child? And what are the efforts made by the mother to see that the child forgets all this and will have a good relation with the father? By the next date of hearing, the petitioner shall place before this court entire record, the days of counseling, when, where, how, and what is the impression or the diagnosis of the analysis of the doctor. This is matter.
My lord, can I make one submission, my lord?
On 13th of August. Huh? More? When? List this matter on 18th.
Maybe 19th, Your Honor.
My lord, can I make one submission? Let there be a direction to the petitioner counsel to tell the petitioner to keep the child present before this honorable court.
Let's not repeat the same story again. 19th, list this matter on 19th.
And my submission may be noted, my lord, in this letter. What they produced the certificate from the doctor is eye specialist. He is my client.
The respondent submits that they are placing before the court that they have taken the child to the doctor and doctor has opined in a particular way. When the doctor is an ophthalmologist,
yes,
how can an ophthalmologist decide or give an opinion about the mental state or the state of mind of a child?
Your Honor, one submission. We have filed an application before the trial court requesting for an independent evaluation of the child, of her psychiatric evaluation. That application is also pending.
We'll see.
It is not that our case, we are going by only
in the
what
criminal
the
case,
counselors have said.
more than 8 to 10 days is over. She was not at all present for cross-examination, not
Yes,
at
next
all.
matter.
And making all these
Correct.
submissions. Much of.
Vinod Kumar M for petitioner.
Yes.
Anand Rama K.
My lord, petitioner is the husband, my lord, filed a petition for declaring the marriage is null and void because they resided together only for 15 days, my lord.
Within 1 month of marriage, he has filed the petition because she has strong aversion towards men, my lord. Therefore, marriage is not consummated. My lord, his take-home salary is 53,000 rupees, my lord. And the trial court awarded him to pay 20,000 per month, my lord. And his father was, at the time of filing, was a cancer patient, my lord. Now he's succumbed to cancer, my lord. And the petitioner, my lord, he is a heart patient, my lord. He's working in bank, but he's a heart patient, my lord. He has 5 stents have been inserted after filing of this petition, my lord.
How much is awarded?
Ordered 20,000 rupees, my lord. Petition for null and void, my lord.
It's okay.
Yes, it's,
that will be
I
decided.
I have not taken that, lord. My lord, my take-home salary is 38,000 rupees. 38,000.
53,000 you said.
38, sorry. 38,000, my lord. I have produced the salary certificate.
What is your salary and what is your take home?
Take home is 33,000, 38,000, my lord. I have produced the document, my lord. 49. Page number 49, my lord.
Your salary
Yes, my lord.
is
Sir.
68,795.
Yes.
And
And
PF contribution 4,196. And another contribution you are making 2,098. That itself is 6,000 and odd. Professional tax 200. Tax 3,656. House rent recovery, then car loan 4,235. Festival advance 6,600. How come it has become 30,000? Even if you take this home, this also 4, 6, 9, 13 plus 6, 19, 21 plus 5, 27.
Yes, ma'am. Now, my lord, I'm a heart patient, my lord. 5 stents have been inserted in my heart, my lord. And doctor have advised I should not take much stress, my lord. Therefore, my
So
lord,
you're quitting your job?
My lord?
You're
No.
quitting your job? Anyhow, whatever the salary you get, you have to work, you will get the salary.
Yes, my lord.
So that your strength and all other things, because you're not doing any regular daily work.
Yes.
Is your job, you work, you get the salary.
Bank.
So as far as the salary is concerned, because of your health, it is not going to make any difference. You will get the same salary.
But
so from that salary, what is the amount shall be paid to the wife is the only question.
Yes, my lord. Yes, my lord. My lord, 10,000 will be ideal, my lord. Out of 38,000, if I pay 20,000 rupees, my lord, the saving is 18,000. I have to take care of my mother, my lord. My father was there, he passed away. Now I have to spend.
Lords, if I may, Your Lordship, in this matter, this honorable court had granted stay of the impugned order, directing them to pay 10,000 per month. As per my instructions, that has not been complied till date.
I've been paying, my lord. If it is not paid, I will. No, as per my instructions.
As per the interim order passed for this court, earlier matters in dismissal, if anybody appears, all that delete from caption dismissal, whether I tell you or not. Earlier matters also, if there is a representation, delete it from dismissal. The learned counsel for the respondent submits that as per the interim order passed for this court, the petitioner has to pay an amount of rupees 10,000. And according to the learned counsel for the respondent, the order is not complied with. Learned counsel for the petitioner submits that he will get instructions. Let's this matter on 19th. By that time, if the interim order, by the time the amount as per the interim order is not paid, the stay granted by this court stands vacated, and on that ground, the writ petition will be dismissed.
Great.
Cell number 9, Sidmalappa PM for petition.
This also delete from the caption dismissal.
For petitioner, please.
Caption dismissal. Yes.
In this matter, I would, just my friend was tell him that trial court the matter was disposed. And
when is that?
1907. I take a instruction.
What instruction?
I'm sorry, Lordship. I'm not aware of that.
No, I will record his submission.
Please,
if anything is there,
yes.
1907-2025.
2025. My London friend.
What is that petition?
It is a diverse petition filed by the
19/7/2025. MC is disposed.
MC.
Land counsel appearing for the respondent submits that the main MC itself is disposed of 19/7/2025 by the family court.
Not family court. Senior civil judge and JMFC Arsikere.
Write that. So the senior civil judge and JMFC
Arsikere.
has disposed of the MC on so and so date. And the land counsel, the respondent submits that nothing survives for consideration. Land counsel, the petitioner submits that that he would get instructions and he will get instructions. Considering the fact that considering the submission of the land counsel, the respondent that the main MC itself is disposed of, nothing survives for consideration. In case if the MC is not disposed of, the petition is at liberty to file an appropriate application to revive this petition.
Grateful.
Yes, next. Is dismissed as instructions. Which IA? In 6, IA number 1 of 24 is filed to condone the delay of 140 days for the reasons stated in the accompanying affidavit. No objections are filed. For the reasons stated in the accompanying affidavit, the delay is condoned.
Cell number 10, Nanjunda Swami N for petitioner. Akash Kumar Gowda for respondent.
The petitioner file an application before the petitioner is a wife.
You're seeking enhancement. You're seeking enhancement.
No, not enhancement. Here what happened, during the husband, the respondent filed a divorce petition before the court. Is pending. Now, during the pendency of that petition, what happened? He married one Anita, and he has a child through that lady.
What required? Yes.
As that we filed an complaint before the competent police station to investigation and file a report, but they did not any investigation. So we filed this present application before the family court and direct the Commissioner of Police Mysore to investigate and file the report regarding whether the respondent is married or whether
such directions can be passed by the court. What is the business?
But it's relevant in the divorce petition.
That is not the concern. If it is irrelevant, you filed a complaint.
That is the reason we have a
complaint is not
complaint already filed.
Let me complete. Let the court complete so that you will understand what is that I'm asking. I said you gave a complaint to the police. Police have not done anything. Petition is not remediless. If police are not considering the complaint, you have a right to file a private complaint. You can't ask the family court to do everything.
And the very
where is the impugned order? Please come to the order.
At annexure the page number 118.
Yes.
Before that, we gave a complaint as per
annexure. Please, let's read the
complaint. Page number 99.
No, please come to 118 and read from the above cases filed by the opponent.
The above case filed by the opponent petitioner, husband against the applicant, respondent wife under section 113, subclass 1. So, under 1A, 1B of the Inter-Marriage Act 1955, seeking a divorce, a decree of divorce. When the case was posted for respondent side evidence, the respondent has come up with the instance application seeking an order to call for the report of Commissioner of Police, Mysore City, Mysore, in respect of a complaint lodged by her against the petitioner on 26/2020 by complaining about the second marriage of the petitioner with one Srimati Anita. According to the respondent in question regarding the second marriage of the respondent is very much essential for the effective adjudication of the present divorce petition. The records reveals that on 26/2020, the petitioner has lodged a complaint before a women police station, Mysore, by alleging that.
Yes, I have seen the order. Yes, now you can make your submission.
Now, kindly peruse the photos. For a moment.
Why is it relevant to produce? I mean, to
see because we have a prima facie.
Yes, let us say that it's your case that the husband has remarried during the pendency of the first marriage, and out of the wedlock they are having a child. That we will accept. Yes.
Then suppose if the respondent accepts, I have no problem. It is a material.
That is not it. Even accepting that, whether such an application is maintainable is the only question now.
The application is maintainable because this reason, is a divorce petition. In the divorce petition, the fact of marriage, of second marriage and birth of a child through second wife is a material evidence because it shows that there is arrogance and there is negligence and mental agony. In order to prove this aspect, this application is very much relevant and necessary, my lord, this fact.
Yes,
That's all my submission.
please come. I agreed with the order passed in I number 8 in MC number 468 of 2021, dated 24/1/2023, whereby the court has dismissed an application filed by the wife under section 151 CPC, seeking an order to call for the report from the Commissioner of Police, Mysore City, Mysore, regarding the second marriage of the husband with one Anita. The wife had filed the husband has filed the MC seeking decree of divorce, and the matter is posted for the evidence of the wife. At that stage, the wife has come up with an application seeking an order to call for the report of the Commissioner of Police, Mysore City, in respect of a complaint lodged by her against the husband on 26/2020 about where she has complained about the second marriage of the husband with one Anita. According to it is a case of the wife that the report in question regarding the second marriage of the husband is very much essential for the effective adjudication of the divorce petition. She has given a complaint on 26/2020 to the Women PS Mysore by alleging that husband has contracted second marriage with one Anita during the pendency of MC number 399 of 2019, that is the present MC.
399, no, my lord, not 399. MC number 468 of 21. MC number 399, which is filed for conjugal rights under section 9 by the husband,
by
it
the
is
wife.
dismissed. It is dismissed.
During the pendency of MC number 399 of 2019. That is the MC for restitution of conjugal rights. And she has produced before the court the complaint that is given by her to the police, and the same is marked as exhibit P17. Both the parties is marked as exhibit P17, exhibit R17 respectively. The court had dismissed the application, observing that it is not the case of the wife that the concerned police have conducted investigation on the basis of the complaint in question and submitted a report either to the jurisdictional court or to their higher official. If that being so, the question of directing the Commissioner of Police, Mysore City, Mysore, to produce the report in connection with the complaint lodged before his subordinate official does not arise at all. That apart, if really the jurisdictional police have submitted any report to the concerned court after concluding investigation, then the wife, who is the complainant, can very well obtain the certified copy of the said report and produce the same before the court. On that count also, the present application seeking issuance of direction to the Commissioner of Police, Mysore City, to produce the report, the existence of which itself is not certain, does not arise. Then the court also observes that it is a case of the wife that the husband has contracted the second marriage. It is the burden lies on the wife the burden lies on the wife to prove the same, and she has to substantiate the said defense by producing the cogent material. The report to the police officials is not a relevant piece of evidence to prove the contention of bigamy. Therefore, the court has felt that this application is not necessary and accordingly dismissed the same. Learned counsel appearing for the petitioner suppressed that when the wife had filed a petition for restitution of conjugal rights, at that time the husband has contracted a second marriage, and out of the
When is filed restitution conjugal
not wife. When the husband has filed a restitution, and during the pendency of the restitution, the husband had married, and in the wedlock, in the said relation, they have a child, which clearly shows that husband has committed bigamy, and in that regard, a police complaint is given Police have not taken any action, and they have not done any investigation. In view of the same, they have filed this application seeking a direction to the police to conduct the investigation and place the report before the court. Or when the issue of bigamy is an important factor in this case, and and if this application is allowed, the entire facts will come on record, and it would be come on record, and it would be in the interest of the wife. As the court has dismissed this application, it would cause a lot of hardship to the wife, and the court ought to have allowed this application. Anything else?
What that is the reason we have a now prima facie material.
What about the submissions to be recorded? Anything I'm asking you? I've recorded anything else to be recorded, I'm asking.
And Lord, he has committed a bigamy that he has.
I already said so. The respondent is sir.
Represented.
Though there is no representation on behalf of the respondent. Heard the learned counsel for the petitioner and peruse the entire material on record. The husband has filed the petition seeking divorce. The matter is posted for the evidence of the wife. At that point of time, she has come up with this application. According to her, she has given a complaint to the police saying that husband has married and has committed an act of bigamy, and she wanted the police to conduct the investigation. Admittedly, police have not conducted the investigation. Then she has filed a petition before the court seeking a direction to the police to complete the investigation and place a report before the court. When a complaint is given to the police and the police are not acting on the said complaint, there is a remedy to the complainant to file a private complaint. Alternatively, in some cases, filing a writ petition before this court, before the High Court, seeking a direction to the police. When the remedy is available to the party, the party has to avail the said remedy. A family court dealing with the maintenance, dealing with an MC seeking divorce, has no business to direct the police to conduct the investigation. That is outside the jurisdiction of the powers vested with the family court. Then, as rightly observed by the court, if the police have conducted the investigation and they have filed a report closing the complaint, or they have filed a charge sheet, in both the cases, the wife would be the complainant would be getting a copy of it, and the same would be filed before the court. The court cannot direct the police to conduct the investigation and file a report, and the court had rightly considered all these aspects and dismiss the application. In the considered opinion of the court had rightly considered the application that is filed and dismissed the petition, and this court finds no reasons to interfere accordingly.
This observation had liberty to file necessary.
You can't. That is beyond the powers of the court. How can the court ask the police
This observation is not coming the way, to file necessary action against not to investigation.
Whatever is it? What is the business of the family court? It cannot. Yes, next.
Cell number 11, VP Sidramaya for petitioner.
Waiting for
Ravi
petition.
Shankar K.
Respondent.
Yes.
Petitioners, the husband, respondents are wife and daughter and son.
What is the amount granted?
5,000 is the amount granted by the family court.
5,000 to petitioner number 1 and 2. That is 10,000.
No, my lord. Page number 51 may kindly peruse.
I'm looking at it.
Petitioner 1 and 2. Whether it is independently or jointly, as there is no clarity in the order. Page number 51 may kindly peruse.
Allowed in part and ordered the respondent to pay interim maintenance of rupees 5,000 per month. What is your income?
My lord, my income is 14,000, 12,000 and 10,000 is the take home salary. I was working in a lodge. The contention of the petition, my lord, is
Please come to the impugned order. Let us read the
at page
impugned
number
order.
48, my lord, para number 26.
Pattern number?
Page number 48, running page 48,
Mm.
para number 26.
Mm.
The respondent has contended that out of the sale consideration of the house, my contention may kindly be seen at page number, and that has not been properly appreciated. At page number 39, para 11 is my main contention. This is the finding of the court at para number 20.
First, we'll continue this and then we'll go back to that.
Yes, please. There is no dispute about the sale house of the respondent. At this stage, respondent has not placed any material to show that an amount of rupees 30 lakh out of the sale consideration was deposited to the account of the petition number 1, and she had to utilize this said amount. Respondent in his objection statement as well as the affidavit of assets and liabilities admits that he is working as a supervisor in.
According to you, an amount of rupees 30 lakhs, the sale proceeds, were deposited in the wife's account.
Wife's account. I have produced the document before this honorable court.
When was that? Date of that transaction?
My date of transaction is on 1/11/2021.
1/11/21. And in the statement of assets and liabilities, whether she has stated about this?
No, she has not stated about this.
Then when is the impugned order?
Whether the impugned order is on 24/8/2023.
24/8?
2023.
And that property belongs to you?
Belongs to my father, ancestral property. I have sold that property. 30 lakh I have transferred to the account of my wife. Remaining amount I have paid to my daughter. She is studying MBBS in Russia.
No. 30 lakhs you have given her. What is the sale consideration?
Well, 78 lakh is the sale consideration.
So 30 you have given to her, and how much towards
31 lakh 87,000 was paid to Punjab National Bank towards loan. The remaining amount I have paid some amount to my daughter for her study of MBBS in Russia. So
30 lakhs, it comes to 61 lakhs.
Yes, sir. The
There's
remaining
almost
amount
62 lakhs.
Yes.
Sale consideration is
78 lakh.
78 lakhs.
That is an
So
unofficial sale consideration, my lord. Officially, it is a less amount. It's an unofficial sale consideration. 78 lakh is the amount I have received. 30 lakh officially I have transferred to the account of my wife.
at this stage, the respondent has not placed any material to show that an amount of 30 lakhs, have you, that 30 lakhs is transferred or not to your account? Yes, file a document also.
That is transferred, my lord. So
And then why have you not stated it before the court? Are you not supposed to, when your petition is filed in the year 2023, the amount that is transferred on 1/11/2021, that is within 2 years from the date of the application. So as per Rajneesh versus Neha, that should contain in your,
so far that amount is concerned. I'll
if
seek
tell
an-
your client, having had that 30 lakhs amount at his
No,
rate,
no, I will seek the
find out,
Please.
this is matter on, which is 11th? 11, 12, 13. full matters
My
are-
lord, let the family court consider all these documents and pass a fresh order, my lord.
So you will be continuing to pay that.
It has to be set
So
aside. It has to be
if you
set
want
aside.
that order, you have continued to pay,
My lord,
I'll
it has
send
to
it
be
back.
set aside and matter.
Will be
needs to
set aside, but you will be continuing to pay till the application is decided.
Maybe highly difficult. My lord. 10,000
You
is the-
can't have both.
Yes, please, ma'am.
Yes. Up to 13. Then we'll have it on 14. MFA day. 18.
18, please.
Yes. This is matter on 18. By the time the learned counsel appearing for the respondent shall get specific instruction about an amount of rupees 30 lakhs that is transferred by the husband to the wife. And why this particular aspect was not disclosed before the family court. Yes, next.
Serial number 12. For orders matter, serial number 12.
Paper appellant, my lord. But I have taken necessary steps to R1.
Why you are not taking?
I have taken RPD, my lord, but unserved the copy.
Who asked you to take RPAD? There was a direction.
Yes, my lord. Last occasion. Third time I have taken the RPD.
Who is that?
Owner of the vehicle.
Liability is on.
Liability fixed to the, both the owner of the vehicle, because the driving license is not on the.
So even pay and recover also his presence is required. Process fee during the day. No, there was no direction that RPAD to be.
Emergent notice is ordered, my lord. I have issued the emergency.
They'll be taking the emergency. The needful shall be done within a week.
My lord, I have taken paper publication instead of I filed necessary application.
When comes for the petitioner submits that already the process is paid 2 times and the notice could not be served on the respondent. He shall come up with an appropriate application within a week.
Within
this, the petition shall stand dismissed against respondent number 3. Yes, next.
Cell number 13, Kevin Narasimhan, for petitioner, B.B. Siddaramaiah for the
Appearing for
respondent.
respondent. My lord, in this matter, my lord, there's an office objection raised on the IA. My lord, will comply with the office objection. Week's time may be granted.
Finally, a week's time for complying the office objections, or else the writ petition shall stand dismissed without further reference to the court. 14.
14, Shivakumaran, for petitioner.
For petitioner, my lord, withdrawal memo has been filed. Withdrawal memo
Withdrawal memo, take it.
has been filed in the office.
You already filed?
Yes.
Yes. Why you want to withdraw?
The party is not registered in the case.
It is submitted as the party is not interested to pursue the matter, hence a memo is filed seeking to withdraw the petition. The same is taken on record. Dismissed as withdrawn. Yes, next. Call for that memo.
Yes, ma'am.
Yes.
Cell number 14, 15. Cell number 15.
The notice to the respondent.
We got, already it is held sufficient notice.
Yes, held sufficient. Your lordship challenged the visitation rights, your lordship temporary visitation rights, which has been granted in favor of the father for totally 4 Sundays, every 4 Sundays, your lordship. Initially, it shall prior to filing the application, at the time of filing application, your lordship, I never come across in between your lordship saying
Please
that.
come to the impugned order. Where is it?
Your lordship, in page number, your lordship, 46. That is the impugned order. In page number 48 is the operative portion, your lordship. Last second line it runs.
40?
7, your lordship, last second line it runs. In the circumstances.
48 is operative portion.
Yes, your lordship. In the fact
Respondent
and
is directed to
circumstances.
hand over the custody of the child in favor of the petitioner every Sunday between 11 a.m. to 4 p.m. You're for the father or the mother?
Mother, your lordship.
So what is the difficulty?
Your lordship, even I have to, your lordship, I need some time to enjoy with my son, your lordship. Not every Sunday, because I never get the Sundays otherwise, your lordship, to spend the time with the children. I have to, to prepare him for the homework. I have to prepare.
Do one thing, give the child to the father, he'll keep it.
Your lordship, he is not at all interested, or he is not at all concerned. Even after this order also, he is not at all concerned over the child.
Then don't
After
bother
filing
about
of maintenance application, your lordship, it is only your lordship, he has filed the application. Divorce petition is filed in the year 2020. I filed a maintenance application thereafter.
Considerations. If the father is not paying the maintenance, it's your duty to bring to the notice of the court and get your IA.
Your lordship, I got a direction by this court to consider the IA for the maintenance as well as the visitation rights. But this only one, this IA has been disposed of, your
Now
lordship.
we will observe that the court, when in spite of a specific direction, if the court is not doing anything, you should bring it to the notice of the court.
Please.
And in this matter, we will not interfere.
Your lordship, not every Sunday, your lordship. I'm seeking only
Then Saturday.
once in.
Then Saturday we'll say.
Your lordship, school is there, your lordship, for the children. I have to, your lordship, every week I have to work. I am also a doctor, your lordship. He got a kidney problem. Son got a kidney problem, your lordship. He has to get his, the only one kidney is functioning, your lordship. I am taking care, your lordship, the son. From day one, he is not at all, during the marital life also, he is not at all shown any kind of love and affection. Those aspects are at all not considered. He has left the matrimonial house, not we have, your lordship, in fact. Therefore, your lordship, I am only 2 Sundays or 3 Sundays, your lordship, so that I can spend 1 Sunday at least with my son, your lordship. Every day, school and
we'll do like
other activities, your lordship.
Second Saturday will be a holiday for the school. Second Saturday.
No, your lordship, there is no holiday on second Saturdays also. For the school, it is a private school, your lordship.
Why not?
Private school, your lordship.
They'll not have second Saturday.
They'll not have a second Saturday also. Only on Sundays there will be time.
He's having, then if you say so, then we will say on vacations he will have 4-5 days.
Your lordship, he is not at all seeking for that one. It is major intention, only temporary. See, kindly see the application.
Not
Your
the
lordship.
reasons.
Visitation rights has been permitted, your lordship. And moreover, your lordship, the son is also, your lordship, if counseling was done by the court. He is not at all ready to go with the father. Your
Then if he's not going, then bring it to the notice of the court.
court. It has been brought to the notice of the court, but this order, your lordship, will be having a bearing, your lordship, on the respondent, your lordship, wife, your lordship. Therefore, your lordship, okay, it can be modified, your lordship, to the extent only at least one Sundays I may be permitted to enjoy with my. That is the
Then
reason.
we have to compensate it on some other day.
Please, your lordship.
On a school
Your lordship,
holidays, on a festival days.
Visitation rights has been sought, your lordship. Here, your lordship, practically, if it is think, your lordship, all 6 days I will be busy with the son to take this thing. I cannot enjoy, your lordship, with the son.
Come, agreed with the orders passed in.
Lordship, one Sunday, your lordship, I may be
Number
modified.
4, in MC number 1926 of 2020, date 4th October 2023, whereby the court has granted the custody of the minor child on every Sunday between 11 a.m. to 4 p.m. Then counsel appearing, agreed thereby, the mother is before this court. Then counsel appearing for the mother submits that mother is a doctor, and if every Sunday if the time is given to the father, she would not be getting any time to spend with the child. As such, it may be the alternative Sundays may be granted to the father. Though notice is served on the respondent, there is no wakalat filed on his behalf. Next para. Having heard the counsel for the petitioner, peruse the material on records. In all these visitation matters, the non-custodial parent, unless and until a weekly visitation is granted to the non-custodial parent, it would be very difficult for the non-custodial parent to develop the intimacy with the child. In all the cases, this court is granting maintenance on every week. The contention that on Sunday, when a mother is working,
Your lordship, no maintenance granted, your lordship.
it should be alternative. Visitation shall be alternative Sundays. That submission this court is not able to appreciate. The whole week the boy is with the mother, and it's only one day, and that too a duration of 11 to 4 p.m. is given to the father. This court do not find any reasons to interfere in his contentions. Then counsel submits that the court has the maintenance is not so far the father is only asking for his rights, but he is not paying any maintenance. He's not conscious of his duties, and is not paying any maintenance. Next, continuation. In the considered opinion of the court had rightly granted the visitation. It is also submitted that the court has already passed an order to pass orders on the IA. Whenever an IA is filed seeking maintenance and seeking visitation rights, it is always desirable that the court shall dispose of both the matters so that the one party is not left in complete frustration. If the father's application for visitation is allowed, and the wife and the child is not granted maintenance, then it would be a reason for the mother will be denying the visitation. And if the father is made to pay the maintenance and is not given visitation, and he would be trying to evade payment of maintenance. Hence, when two applications are filed, it is always desirable that the court should at a time dispose of these applications. In this case, IA for visitation is disposed of, but IA for maintenance is not heard by the court. The court shall dispose of this application within 1 month from the date of receipt of the copy of this order. And this court finds no reasons to interfere with the order impugned.
Till number 16, Rajat, petitioner, Bellari.
My lords, I request for a short accommodation, my lords. The council on
No, my
record
lord.
is not well today. It may be taken up tomorrow or day after. He's just not well today, my lords.
My lord, the other side has falsely submitted in the pleadings and blaming the trial court, though the proper order has been passed by the trial court, suppressing the.
It is not blaming now.
My lord.
Please listen, any person who is aggrieved by the order will come to the.
Yes, I too agree, my lord, but on looking into the very facts and the grounds made in the petition, my lord, there they have been submitted that in the grounds.
And counsel for the
and
petition
further, my lord, on 2/5/2025.
This is matter.
My lord.
List this matter tomorrow. The office objections, who has to comply? Petitioner.
The petitioner has to be compliant.
Petitioner shall comply with the office objections by tomorrow. And that would be if the office objections are not complete, having obtained an order from this court, that would be the ground for this court to dismiss the application.
The interim order may kindly.
No, it cannot be. It
Interim
cannot be
order earlier
extended, my lord.
granted is extended till tomorrow.
Much obliged.
17.
Till number 17.
Await service of note. What about hand summons?
Hand summons was served, my lord, and acknowledgement was filed.
Please give that order. As per the order passed by this court, the counsel for the petitioner has taken out notice of the counsel appearing to the respondent and filed a memo to that effect. The same was served on which date?
Served on
29/7/2025. Print the name of the you are here. You want to engage the advocate.
No, ma'am. Advocate illa, madam. Madkolbeku.
What is that? You want to engage.
Lawyer na put ಮಾಡ್ಕೋಬೇಕಾ?
ಹೌದು.
The party is present before the court and seeks time to engage the advocate. How much time, ask her?
ಎಷ್ಟು ದಿನ ಬೇಕು?
ಮೇಡಮ್ ನಾನು ಮಡಿಕೇರಿಯಿಂದ ಬಂದಿದ್ದು ನನ್ಗೆ ಇಲ್ಲಿ ಯಾರು ಗೊತ್ತಿಲ್ಲ ನಾನು ಈಗ ಕೇಳಿ ಮಾಡಿ ಲಾಯರ್ ಮಾಡಿ.
She wants to engage anybody from Legal Services Authority, ask her.
ಈಗ ಕೇಳ್ತೀನಿ
7 days.
ಅಷ್ಟೇ.
Legal services in the.
The party submits that they want to engage an advocate from the Legal Services Authority. The party shall approach the Legal Services Authority and they shall appoint an advocate for the respondent. List this matter on 19th of August. Today itself you go.
Thank you.
Go to the Legal Services Authority.
Interim order kindly.
Interim order earlier granted is extended till then. Yes.
Till number 18, interlocutory application, order Pradeep Beef for appellant.
In 17, no, they will again keep it like this. Notice is already served on the respondent. Respondent is in 17. That office objection with regard to that. Yes. 18.
Till number 18, Pradeep B. Syed Abdul Sabur.
No representation. List this matter for dismissal tomorrow.
Till number 19.
I appear for the petitioner, my lord. There is a delay application, my lord, 226 days.
Filing my statement of objection
Yes.
to the IA condemnation of delay. There's a delay of 226 days, my lord.
Let's see the reasons stated in the delay
Please, my lord.
application.
And the delay is, my lord, previously, my lord, we have filed a criminal revision petition, my lord. Later it is withdrawn and filed. Before, my lord, it is informed through phone to the petitioner. It is partly allowed. She did not understand properly and later she approached me what happened to the judgment. Then I explained that, then she understood that.
Just hear it in the minutes. Mr.
My lord,
IA number 1 of 24 is filed to condone the delay of 226
But
days.
there's absolutely no reasons. May I just submit?
We'll hear it in the minutes.
So great. As your worship pleases.
The petition is partly allowed. And he was under the impression that the petition is in his favor and later came to know that it is partly allowed. Accordingly, hence in this process a delay of 226 days occurred. Learned counsel for the respondent submits that there are absolutely no reasons to condone the delay. And he has filed his objections. Objections are taken on record. Considering the fact that it's a partly allowed and the reasons that are stated, the delay of 226 days in filing the petition are allowed on the cost of ₹1,000 to be paid to the husband. Yes, what are the grounds for the Enhancement, please come to the order.
Millard, we have produced exhibit 8 to 16, Millard. To show that the husband is having immovable property of around 11,200 square feet in K.R.Puram. It is the heart of the city of the Bangalore. And also he is earning a sum of rupees 25,000 and also getting the rent. But that is not considered. My documents are not
How much is
considered.
getting, how much is getting as rent according to you?
Millard, it's a small houses, shed houses, Millard, I think some 10,000 to 15,000 rent he is getting, he is earning 25,000 rupees salaries and he is having immovable property of some 7 to 8 crores.
It is for the wife to say what is that, how much you are saying. 25,000 is his income. Then
Yes,
from the landed properties, what is that he is getting?
Millard, some 10 to 12,000 rupees he is getting as rent.
Let's take whatever you say. So according to you, it is 12,000.
Yes,
so
ma'am.
how much it becomes? 37,000.
Please, Millard.
So what is the amount that is granted by the court?
5,000 rupees, Millard.
Huh?
5,000 rupees, Millard.
Yes.
May I submit? Not even a single centimeter of land that I own. There is, my lord, a case which was filed by me and my wife jointly because my lord, we are on common ancestors. She is, my lord, a close relative of mine. From the day one, my lord, the day one that my daughter is born, I've been looking after her. She has, my lord, deserted me from the year 2007. My daughter was born in the year 2005. And I do not own a single piece of land, my lord. I'm sorry, my lord, I do not have a memo to place, but this is the judgment, my lord, which has been passed by the learned trial judge, that there was a suit for declaration and injunction which was filed by me as well as my wife. That was, my lord, dismissed. Yes, my lord.
Very same properties is referring to.
Please, not even a single sentiment. I'll, if your lordship pleases, my lord, give me a week's time, my lord. I'll file an affidavit.
Then counsel submits that petitioner is having landed properties and is deriving some income from that. The same was not considered by the court. Then counsel for the respondent submits that as stated by the petitioner. Those properties or the petitioner do not, the husband do not own those properties, and he will come up with the necessary documents in that regard. Does this matter when?
Any date convenient to your lordship
Does
next
this
week.
matter on 19th?
May I just place, my lord, subject to your lordship's approval. Let there be, my lord, a direction to both husband and wife. I'll file, my lord, what is the property that I have, what is the income that I have.
Anyhow, you have not questioned.
May I just, my lord, let the wife also, my lord, file an affidavit that she is not remarried. To that extent.
Yes, my lord.
Marriage is dissolved. Marriage is
Like
dissolved.
counsel for the respondent submits that as per his instructions, the wife is already remarried and she is not entitled for any maintenance. The wife shall file an affidavit before this court that whether she is married or
Please.
not.
So great.
Trial court record shall be called for.
May I just retain that copy, my lord?
All trial court records are not required.
With my lord's permission, may I just retain that copy so that I'll file with a memo, the judgment copy.
Just now he has given. Give it
Please,
to
please.
Yes, next.
So great.
20, Sachin BS. 20, Karat Gowda GP, Sachin BS.
For the petitioner. Maintenance order murder, seeking for enhancement.
Will condone the delay?
Yes,
Item
madam,
number
may be
125 is filed to condone the delay of 61 days in filing for the reasons stated. It's condoned. Yes.
Please, my lords.
Where is the impugned order?
My lords, page number 9, my lords.
Page number?
9. Operative portion is at the page number 26, my lords. Maintenance of rupees 10,000 is granted, my lords. I have sought for 40,000 maintenance, my lords.
You sought for?
40,000, my lords.
40,000.
Please, my lords.
10,000 is granted.
Please, my lords.
What is the income of the husband?
My lords, husband is my lords, chartered accountant, my lords. We have claimed that he is earning about 1,50,000, my lords. But in
Has
his,
he filed his income tax returns and all?
please, my lords,
Shows?
he has stated in the assets and liabilities, my lords, he is earning only about the rupees of 24,000.
So what is the reason now for to enhance?
My lords, the reason is this, my lords, he is also having agricultural properties and he is also having other incomes also, my lords.
So you must have placed something on record. He must have said something on
Please,
that.
my lords, in the his assets and liability only, my lords, he claims that he is a partnership of an LLP, my lords, and he is getting the profit from that also, my lords.
How much he's getting?
That is not stated, my lords.
My lords, in their assets and liabilities, they state that the wife is not earning at all, whereas
my lords.
she's working in State Bank of India, my lords.
Please, my lords, in the initially while filing the application, my lords, I was not working. Subsequently, my lords, I got an appointment from the SBI, my lords. Now I am working as a junior associate. So that has been placed in record also, my lords. I was submitted in Exhibit 24, my lords.
How maintenance is given to whom?
Wife, my lords.
Then what is your income as an officer of the State Bank?
My lords, my salary is, my lords, 33,162 rupees, my lords.
And why you require maintenance of another?
Because
why you want
reason is this,
enhancement
my
of,
lords. Reason is this, my lords. I am staying with my parents now in a rented house.
No, on record.
Please, my lords.
Husband's income is 24,000.
Please, my
You
lords.
claim it to be 1 lakh. Your income is 33,162.
Please,
Why
my
should the husband give you maintenance now? From
Yes.
his money, we can understand he's earning better than you, basing on the material available on record.
Please, my lords. I am
On
not able
record,
to
they
secure
have
the
placed
materials.
us
my lord. That is the
unemployed,
reason,
my
my lord.
lords.
That's it.
So we will set aside this order, allow their petition, dismiss your petition. Please come. The agreed with orders passed in criminal miscellaneous 761 of 2021.
My
Dated.
lords, one submission, my lords. There is arrears of, my lords, 4 lakh.
That's what, when was the order?
My lords, it's in the order was in the year, my lords.
Date of order?
Arrears has
12
been
lakh
paid
is-
off, my lords.
No, my lords, as per my
13th
instruction.
August 2024 is the order.
Please, my lords, from the
When is
date
the
of
petition filed?
23/11/2021, my lords.
23/11/2001. When is your employment?
2021, my
When,
lords. 44 months, my lords.
when you got the job?
I got the job on, my lords. Just a minute, my lords. I got the job, my lords, 24/8/2022, my lords.
24/8/2022.
8/2024, my lords, as per Exhibit 24. 22.
2022.
Please, my lords.
No. 23/11/2021 is the application.
Please, my lords.
So it is not even a year, less
Please.
than a year.
Please, my lords.
8, 9, 10, 11. That is around 9 months.
Please, my lords.
Only for a period of 9 months to pay the maintenance.
For 9 months.
9 months. 9 into
10,000.
90,000.
Please, my lords.
Agreed with the orders passed in criminal miscellaneous number 761 of 2021. Not it. 13th August 2024. Both the wife and husband are before the court. The husband's petition is RPSC 216 of 2024 and the wife's petition is RPSC number 17 of 2025. The court by order impugned had granted an amount of rupees 20,000.
10,000.
10,000
Please.
and 5,000 towards expenses. It is the case of the wife that the husband is a CA earning 1 lakh and is also having landed properties. It is a case of the husband that he is earning 24,000 and the court had granted maintenance of an amount of rupees 10,000. Learned counsel appearing for the wife submits that he is having landed properties and also is getting 1 lakh per month, at least 1 lakh per month. These aspects were suppressed by the husband before the court and the wife is entitled for maintenance. Learned counsel appearing for the husband submits that the wife as on she got the job on 24/8/2022 in State Bank of India and her salary is 33,162, whereas husband's salary is 24,000 and is not entitled for any maintenance. As such, the petition filed by the wife needs to be dismissed and the petition filed by the husband has to be allowed. Next para, having got the counsels on either side, where is the material on record? The application seeking maintenance of the IA is filed on 23/11/2021. The impugned order is passed on 13th August 2024. The wife got the job on 24/8/2022. Job on 2020, that is for a period of 9 months after the application is filed. She is unemployed. Thereafter, she got the job. In these circumstances, this court is of the view that whatever is the amount that is decided by the court, the arrears at 9 months shall be paid by the husband. And as she is already drawing more salary, and there is nothing on record to show that the husband is earning more than the wife, the enhancement of the maintenance or her entitlement after 24/8/2022 does not arise. In that view of the matter, this court is passing the following order. The RPFC number 17 of 2025 is dismissed as she is not entitled for enhancement of the maintenance, and also she is not entitled for enhancement of maintenance. Then coming to RPFC number 216 of 2024, RPFC number 216 of 2024, the order dated so and so is the RPFC is partly allowed, and the wife is not entitled for maintenance from 24/8/2022, and the husband is liable to pay the maintenance at 10,000 for a period of 9 months, that is 90,000. Accordingly, the petitions are ordered. Yes,
Number
next.
21 adjourned. 22. 22 Shivaram HC.
What is this modification of interim order dated 8/5/2018?
My lord, already the MC case has been dismissed on 3/5/25, my lord.
3/5?
My lord.
You are for the respondent?
I'm for the respondent.
Then no representation for the petition. MC is disposed of accordingly. It is submitted by both the counsel that the MC itself is disposed of on 3/5/2025. Nothing remains to be considered in this petition, accordingly dismissed as infructuous. Yes, 23.
23.
Yes, what's up?
Arun Govindraj. For petitioner Geeta G. Menon.
For the respondent. Just before the submissions are made, if your lordship sees the order dated 9/11/2023 passed by this honorable court, the petitioner had been directed to file her list of assets and liabilities. It's almost 2 years, they are still not filed.
I'm sorry, the affidavit is ready, but today she's not in the, she's feeling extremely unwell.
The order passed by the court.
9/11/2023.
Thereafter, there were 2 hearings, my lord, at which time the father was directed to pay the educational expenses. The affidavit is ready, my lord, but she's not in the position.
This matter on 19th.
May I also make one request, my lord? The father also has not filed the affidavit, though the direction is only to me to file. He has opened 4 companies in the last 1 year. We have got the.
The respondent also shall place before the
I had
respondent
earlier
husband
filed. I
shall
filed a
place the
revised one
fresh
because this honorable court.
revised statement of assets and
madam.
liabilities and shall serve the copy of the same in advance to the counsel for the respondent as well as to the counsel for the wife, and the wife also, and the counsel for the wife also shall serve the same in advance to the counsel for the husband. List this matter on 20th of August.
20.
Yes, please.
20th.
20th of August.
19th, may I request?
19th, yes.
Cell
Yes,
number
next.
24. Cell number 24.
For the
Geeta
petition,
Devi
my lord,
MP
both the
for
applications
petitioner.
have been filed by the respondent, husband, my lord. Both has become infructuous now. It may be.
My lords, due to a minor inconvenience, I seek for a short accommodation regarding this matter, my lords.
May I, my
No,
lord?
that's their petition. They say that nothing survives.
Please, my lords, senior is instructed to have this matter on 13th, my lords. He had to make a few submissions regarding this matter.
No, he was not aware about this submission, that the matter has been.
My lord, even I have filed my objection saying that now he has filed 2 applications. One is for summer vacation, my lord. And the other one is for modification of your lordship's order dated. Your lordship order is very clear to mentioning that yesterday visit 1st and 3rd Saturday, convenient 10 to 3 p.m. my lord. Now he wants to change the timings from 1 to 7 p.m. Meanwhile, he has filed an application before the family court for weekend
The
custody.
applications are filed by whom?
Husband, respondent.
Then we'll hear it.
But no, my lord,
The GNWC is disposed of.
not GNW, MC matter, only one matter, MC matter.
In MC, this order is
Please,
filed.
please. And my lord,
When
in
is the
MC
date
now,
of order? Date of disposal of MC.
MC is not disposed, my lord. My lord, this petition came up with regards to visitation was granted overnight custody without weekend visitation, nothing, my lord. Then your lordships are.
Please give the order. Which order they are seeking correction? What is the date of order?
Lord, your lordship's order is on 4/9/2024, my lord.
Already petition itself is disposed of.
Yes, my lord.
Oh.
Now, my lord, your lordships have specifically given direction on your operative portion, my lord.
On first and third Saturday.
Please, Now he is seeking for modification from 1 PM to 7 PM. Now, my lord, already has filed an application before the trial court for weekend visitation. Now, my lord, this application and the second application does stand for consideration, my lord. It has become infructuous.
No, come again. What is that?
My lord, now your lordship's order is on 1:11 AM to 4 PM, my lord.
Correct.
Now he is seeking modification in this from 1 PM to 7 PM.
1 PM
To
to
7 PM. And my lord, and the other, your lordship's order, operative question 8, my lord. During Dasara vacation, any 2 days, father prior intimation can meet the child in Bangalore. He has missed it. Now we are seeking for modification of this.
It is not particularly for 1 year. No, till further orders are passed, this order will be in force.
Please,
So
my lord.
Dasara vacation is coming.
No, this is with regards to 24, my lord. Previous year.
No, court has not specifically said that. It is all, arrangement is forever. For Dasara, no,
Please.
last year Dasara, this year Dasara, next year Dasara, till any applications are filed by you or any other modification to this order, it will remain. So how it will become infructuous?
No. In this, my lord, he is saying that he wants, now the Dasara what he has placed here, my lord, he has been missed. He didn't visit, as per this, your lordship direction, my lord, he didn't visit the child in the Dasara vacation. Now we sought for compensation as at Diwali in 24.
And what kind of application is this? No, the court disposes this petition on 4 September 2024, and you come up with this modification. Easily, it is already a disposed of matter.
And my lord, again he has filed an application for summer vacation.
This matter tomorrow, when I'm going to dismiss this, I tell your senior.
Please.
Yes.
Case number 25, Praveen.
For the petition, my lord.
Yes.
My lordship, we have filed the present writ petition calling in question the ex parte maintenance order passed by the court below, my lordship.
Yes, where is that?
My lordship, the facts of the case.
No, we'll go to the impugned order straight away, then you can.
Yes, my lordship.
Page number?
19, my lordship. It starts from 12, my lordship. The operative portion is in 19. 5,000
So the
rupees.
amount that is granted is?
5,000 for the wife, the respondent.
Plus 3,000. That is 8,000.
That is
8,000 is
8,000.
granted.
That is right, my lordship.
And what is your salary?
My lordship, he doesn't have a salary. He is an uneducated person and a landless agricultural laborer. Both the parties are uneducated. He works for a daily wage of 350 rupees and he's from a rural area. He earns about 14 to 16,000 rupees per month. He's also taking care of his parents. He can pay about 3,000 rupees. And moreover, my lordship, at the time of passing this order, there is a certain observation by the court in page number 18, my lordship, para number 11, that may be perused. It says in the ex parte order, though it is the contention of the petitioners that the respondent owns a residential house and garden lands and is doing business, it says alemani. Alemani means he's working in a jaggery making unit and thereby earning 70 to 80,000 rupees per month. That's the claim. They have failed to produce the available documents in this regard. The only documents produced by...
Extent of 5 guntas of land is in the name of the petitioner.
No, my lordship, that is the observation I'm reading out. The only documents
By
produced...
virtue of a sale deed dated 12/1/2022.
Yes, it's in the name of one Mahadev Swami, and there, I have nothing to do with Mahadev Swami. And 5 guntas is barely 5,000 square feet of land. 5,000 square feet of land, nobody can grow anything. And that is also not in my name. And that is also not my land. He's an agricultural labor. He's a landless.
Gunta is how much?
1 gunta is 1,000 square feet. Thereabouts, maybe 1,023 or something, but it is 1,000 square feet. 5 guntas is 5,000.
Exhibit B only reveals that in column number 12 of the said RTC, in the name of the father of the respondent is mentioned. That is Mahadev Swami.
That is right, my lordship. It cannot be concluded that the respondent is having any interest in the land. That is the observation of the court, my lordship. He's a landless agricultural labor, my lordship. He does not have the means to pay this. An opportunity should have been given to him to contest the particular matter, my lordship, but they were a wrong address was
This happened right from 2024. This matter is of the year 2024. So far, notice is not ordered. In the morning, the learned counsel, the petitioner, had sought for time. Matter was passed over. Again, seeking time.
I was not in court. I was before another court, my lordship.
No,
My apologies.
This is filed on 22/2/2024.
That is right, my lordship.
So then the petitioner is not interested for any.
My lordship, typically the petitioner is an illiterate person, uneducated person.
No, but the advocate is not.
No, the advocate is not,
Then
my
you
lordship.
have
We
to-
had moved memos in the past, my lordship, but some of the
No,
matter
we'll have the memos here. Let's see how many memos you moved.
you would have
If at all you have moved. They'll be there in the file.
I have moved a memo on 7/8/2024 itself, my lordship.
That is long back, very
Yes,
long
my
back.
lordship, that is right.
So I don't know. This is notice to the petition is permitted tag issue. Shall take hand summons on the counsel appearing for the respondent and shall file a memo to that effect by 20th of August, or else the writ petition shall stand dismissed without further reference to the court.
Bill number
Interim order, my lordship.
What
We've
interim
sought
order?
for stay of the order, my lordship.
Which can't be granted. Yes,
Notice is issued, my lordship.
yes.
Oblige,
It
my
will
lordship.
count by 20th if you don't
Hand
file the memo having taken out hand summons.
We shall do the needful,
petition
my
will
lordship.
be dismissed.
My lordship, we may be given some more time because this is not in Bangalore. This is in a rural district which is quite far from Bangalore. We may be granted a
This
slightly
is matter
longer.
on first
Oblige, my lordship.
default order. Yes, next.
Cell number 26, dispose 27. Hemalata BV, for petitioner.
Petitioner seeking modification of the order, wide annexure of my lord, impugned order. Page number 54, my lord, regarding visitation rights, my lord.
Till now in this also notice not ordered. Let's see the impugned order. Where is the impugned order?
Page number 54, my lord. Sufficient visitation right is
One
not.
minute. 50?
4, my lord, page number.
IA number 1 filed under section.
Section 26.
is hereby allowed. The respondent shall permit the petitioner to meet his son by name on any day in a week at time and place preferred by the respondent. What is wrong with it?
My lord, from till 1 year from the order, respondent has not showed the child, my lord.
That is a different aspect.
Yes, my lord.
Now, court has already granted you a
Yes.
visitation on once in a week. That's fine.
Yes, my lord, any day it should be mentioned, my lord, at least, because every day child should go to school, no, my lord. For that weekend may be given, because
What the court says, if you ask the mother, if it is, if he is going to school, they will say Sunday. If Saturday, that's not your problem. You have to tell the mother has to say, as per the order.
even, yes, my lord, even petitioner.
She is not, if she is not, you can say, I want to have it on Sunday.
Yes, my lord, even petitioner have filed a memo also, my lord. It's respondent is not obeying the court order and all.
That is, we can't help it. That you have your own remedy and this is, you are waiting for this from when this order is passed?
Passed
when?
on
8/12/2023.
Yes, my lord.
And from that day, you are not, if really you are interested to meet the child and the mother is not showing, you would have done
Regularly,
something.
petitioner is filed memo, my lord, but it was not considered.
Please come. Agreed with the order passed in.
Kindly, any day may be fixed, my lord.
Number 107 of 2022 dated 8 December 22. This modification, clarification, you should have asked before the trial court. Without doing that, you came to the High Court, you are waiting from 2023 for this clarification. That shows the bona fides of the father. Agreed with the orders passed in, passed on an application under section 26 of the Hindu Marriage Act dated 8 December 2023, whereby the court had permitted the father to meet his son on any day in a week at time and place preferred by the respondent. The respondent is the father. The father is before this court stating that the court has not meant, the court has not, the mother is before the court.
No, father is before the court, my lord.
This is
2023, my lord, passed.
Which writ petition number?
36548.
36548.
54F20.
The father is before this court. That the court has not clarified the order, has not given a specific date, and the mother and the other, the learned counsel for the petitioner, father submits that the mother is not complying with the order. Next paragraph. This writ petition is filed in the year 2024 and the order is passed on 8/12/2023. Right from 2023, if the mother is not complying with the order passed by the court, the father has his own, the father has a remedy to enforce the said order. Admittedly, except filing a memo, nothing has been done. Then in this order is in fact advantageous to the father. The court says whenever it is convenient to the father, the visitation has to be exercised. If this order is questioned by the mother, at least the court can understand. How the father is aggrieved, this court is not able to understand. If if Sunday is convenient to the father, as per this order, the mother has to oblige the same. In that view of the matter, this court do not find any reasons to interfere. If the order of the court is not complied with, the petitioner shall, the father is at liberty to file an appropriate petition. Hence, this court finds no reasons. Dismissed.
Cell number 28, Raju CN for petitioner.
Yes.
My lord, petitioner filed this petition to direct the trial court to expedite the proceedings.
Which year is the MC?
24, 27/4/24 he has filed, my lord. Till today is not posted for evidence. Respondent is not cooperating.
When is
Respondent,
it? MC is of which year? 24.
24, my lord. Earlier I filed restitution of conjugal rights. She has not
No,
written.
no. Why should this court direct the family court to take care of some case which is of the year 2024? Now the cases of 16, 17 are also.
No, my lord, I filed 23, my lord. That has been disposed.
Let it be 23.
I produced the copy also, my lord. She is not cooperating.
Please come. The present petition is filed to dispose of MC number 467 of 2024, pending on the file of the Principal Judge Family Court at Mysore. It is submitted with the land council that earlier he has filed a restitution. Now the present petition is filed seeking divorce. And the court and the wife is not cooperating, and there shall be a direction to the court. An MC of 474, an MC of 2024, there cannot be a direction to the family court to dispose of the matter expeditiously. If the wife is not cooperating or she is seeking unnecessary adjournments, it is for the petitioner to bring it to the notice of the court. And for that particular, if the grievance is not addressed, he can come before the court. But that cannot be a reason to direct the court to dispose of a 24 MC when much older matters are pending. Accordingly, dismissed. This next.
Cell number 29, Urmila Pullat for petitioner.
My lord, this I've challenged the order for interim maintenance by the family court.
Yes.
On the ground that I'm the husband, the wife is also a doctor and I'm also a doctor.
Granted maintenance.
20,000 per month, my lord.
Children are
But
there?
one child. But the
What
fact
is your
is,
salary? What is your income?
my income is, as per my pay slip, it is 48,900. But I also have a clinic. There I get variable income, my lord.
Has it come before the court earlier?
Yes, my lord. I had argued it. Because you had, my lordship had asked for me to seek instructions on how much maintenance I've paid so far.
Yes.
So I have paid 1,50,000, my lord, for the child. 20,000 is the amount, and I'll submit fairly, my lord. The payment was made today morning as an arrears for the last since April 2020.
When is the order passed? April?
2024, my lord.
April 20. When is the application? Petition IA.
April 24. Order is my 1 minute. April 24 is the application.
April 24 is the application.
Application, my lord. Order passed on 24/2/2025.
24 to 2025.
So it said that
April means from April to now, how many months? What, 12 months plus May,
15
June,
months,
July,
my lord.
August. 4 months.
15.
So 12
August
plus 4,
just.
16 months. 16 into 20.
Yes.
16 into 20 is
Yes,
paid.
my lord.
How much it is?
No, 16 into 10 I have, 15 into 10 I have paid, my lord, taking till the end of July. 1,50,000 I have paid so far for the child. The order only says 20,000. It's not split between the mother and the child, but I have paid towards the child because my contention is that I should not be made to pay for my wife also, because
Petitioner submits that the court has granted maintenance to the wife and the child at rupees 20,000. It is submitted that both are doctors.
yes, my lord.
Both are
And there's
doctors.
already a DV case in which 50,000 already awarded.
Both are doctors, and in the DV case, already the husband is paying 50,000.
Not paying, my lord, awarded. We have appealed that, my lord.
The court has awarded 50,000 in the domestic violence case, and against which an appeal is preferred. It is submitted that from the date of application till now, an amount of rupees 1,50,000 is paid towards the maintenance of the boy, the child.
Yes, my
and
lord.
they will, and the husband is ready to pay the amount of 10,000.
Yes, my lord.
10,000. What is the age?
4 years old, my lord. But
Pay 10,000 And
She's not permitting me to meet the child, completely no contact, so I'm not aware. Very well.
And till July, for 15 months, an amount of rupees 1,50,000 is paid. Considering the submission, there shall be stay of all further proceeding. Pursuant to the order dated so and so, on the condition that the petitioner should continue to pay 10,000 by the 5th of every succeeding month. If arrears, if any, shall be cleared within 2 weeks
2 weeks.
at 10,000. Anyway, you paid,
Yes,
but still a
madam.
rider. And the petition is permitted to hand summons on the counsel for the respondent and shall file a memo to that effect by 28th of August, or else the stay granted by this court stands vacated even on that ground.
Obliged.
Bill number 30, adjourned, 31.
Yes, 31.
Chief.
The petition, my lord.
AC is there.
My lord, the court below has passed an impugned order. I file an application, my lord.
Getting there. Yes.
My lord, impugned orders at annexure F, my lord, page 44, my lord.
Page 44.
Please, my lord. Because for both me and my wife, it's a second marriage, my lord.
Mm.
My wife is working in a.
What is the amount awarded?
No, well, recently, because I filed an application to summon the drawing officer of my wife's.
IA number 5 filed with the petitioner paying for summoning of drawing officer of MPS Limited is dismissed. IA number 6 filed by petitioner. Direction to produce document is disposed as do not survive. MC is of the year 2021.
Please, ma'am.
What is this? You who filed the MC?
I filed the MC.
MC for divorce.
Please, ma'am.
Then
When matter is pending, she filed a 24 application.
No. What is the stage, present stage?
Stage now it is for the evidence of the petition, ma'am.
Evidence of the petition.
Please, ma'am.
So you have filed IA number 5
Please, ma'am.
to summon whom?
Drawing officer of the respondent, my lord. My wife.
What is the purpose? Where is
My
your
lord,
IA?
she joined, my lord, kindly see annexure H, my lord,
No,
page number
let us
52.
see your IA.
I, my lord, page number. Annexure D, page number 39, my lord. Order 16, rule 6, my lord.
Let's see.
Because, shall I submit, my lord?
If the book is present, false claim maintained is opposing the correct salary.
From the beginning, my lord, all along she suppressing the material fact. For her also it is a second marriage, for me also second marriage. Where in her first, out of her first marriage.
No, on where is the other application? Second one that is dismissed. You are not contesting on that.
No, I'm not contesting.
Then please come to the impugned order.
Impugned order is at page 44, annexure F, my lord. IA number 5 and order.
Let's see paragraph number 6. Paragraph number 6.
Please, my lord. In this petition filed for the divorce on the ground of cruelty by petitioner, respondent has appeared and IA number 3 under 24 of Hindu Marriage Act of 55 seeking interim maintenance. Application is opposed by the petitioner husband as required. Both parties have filed affidavits of assets and liabilities regarding her income from her employment. Respondent has stated particular amount as she is getting, and petitioner disputes her salary income from the employment and for the purpose. He is prayed to summon the drawing officer of the company in which respondent is working, and petitioner has also stated that respondent had earlier obtained divorce from the divorce and amount received by her first husband, and same was not disclosed by the therefore she is to be directed to produce documents and also particulars of income tax returns and also salient of the site which she was gifted by a father. In respect of these application, respondent has produced copy of the order of the Honorable High Court of Karnataka in MFA number 1845 of 2004 by which divorce was granted. Respondent has stated that she has received rupees 4 lakhs as permanent alimony from her previous husband, and she has not received any other maintenance amount. In the High Court order also, it is mentioned that her previous husband has paid rupees 4 lakh rupees to the respondent by way of DD dated 4/9/2004 as permanent alimony. Since the permanent alimony is paid As per this order, respondent is not receiving any other amount. As regards to income tax computations, she has produced income tax computation for 3 years. Even her salary slip for December 2023 is produced by the respondent. Respondent has produced most of the documents which was sought by the petitioner. One more document sought by the petitioner is salient of a site which was gifted by her.
In the order.
Please, my lord. My lord, for my wife also it is second marriage, for me also second marriage. And she had received 4 lakh rupees from first husband in MFA number 1845 of 2004. Purposely, she has suppressed the
That
material.
is not the issue at all. No,
Please,
the
ma'am.
issue is
Now-
with regard to the drawing officer.
Please, my lord. Shall I take my lordship to annexure H, my lord, page 52? She joined the service of a multinational company on 1/2/1994. She worked for 30 long years. At present, she is working as a team leader in a company. Team leader, and she is drawing not less than 1,50,000 rupees salary. She is in a high post. Whereas in her assets and liability application, she claims that her salary is only 28,000 rupees. But a person worked for 30 long years in a MNC company. Can this honorable court believe that?
No, she has placed before the court her salary slip
Please, my lord.
and she has also placed her income tax returns.
Please.
Now, if you say that this is what it is, even the court has rightly observed that if the said document is a false or a fabricated document, court can, you can initiate, application can be filed to initiate perjury proceedings.
Please, my lord. But in fact, my lord, kindly see annexure H.
Income tax returns from a multinational company she is working. She files her income tax returns, salary certificate as issued by the
That is a
company.
fake, my lord. According to me, it is a fake. A person who worked for 30 long years,
That
how
is
can he
your
draw a
assumption.
28,000 rupees
Is your
salary? My lord?
assumption.
Here, my lord.
What is
One
her,
more thing, my
what
lord.
is her qualification?
Page number.
What is her qualification?
She's BSc and 2 diplomas in with her thing, my lord. And here the annexure H says that her salary is 38,141. This is a salary slip. I got it
Income
from.
tax returns also. Can you say that even income tax returns are also wrong?
No,
In
what
that she
is
will be
wrong, my
showing-
lord?
In that, she will be showing her salary also, basing on that, because it's an MNC. Before they have to, they will cut the tax.
Of course, my anxiety is, my lord, what the court would have summoned this drawing officer.
That is
Thereby,
what I said.
it would have very clear. But here, my lord, her claim is her salary is 28,000. Whereas the annexure H says, my lord, her salary is 38,141. There's a difference.
38 will be considered.
No. Then why she claimed that the salary is only 28,000?
Okay, that's why you file an appropriate application for all suppression of facts. So
Please,
for
madam.
that, not necessary that drawing officer has to be called.
That's
Please,
what my
ma'am.
application is rejected.
That's why not required, please. Agreed with the orders passed on I number 5 and 6 in MC number 527 of 2021, dated 27th April 2024. Whereby the application filed by the petitioner husband under section, that's IA number 5 and 6 are dismissed. The dated by order date 27/4/2024. The husband is before this court. The husband has filed the MC seeking divorce. In that, the wife had filed an IA seeking interim maintenance. And the matter is coming for the evidence of the husband. At that point of time, 2 applications are filed. One application, that's IA number 5, is praying to summon the drawing officer of NPS Limited, and the other IA is under section 151 of the CPC, seeking direction to produce certain documents.
And on submission, my lord, she had landed properties also worth more than 4-5 crore. And I also furnished the documents to that effect to show this honorable court, my lord. Your Honor, kindly see the page number 50, my lord. She
So
got a
that
palatious house. She also gets a
That is not-
rent
that-
of 18,000 rupees per
That is
month.
not relevant for this IA number 5.
No, of course.
The court had dismissed IA number 6 as already the wife has produced the documents, and all the majority documents are produced and nothing survives for consideration. Then counsel for the petition submits that the petitioner is not on IA number 6, but he is agreed with the order in IA number 5, where the court has refused to summon the drawing officer. This court has perused the order passed by the court. While dismissing the application, the IA number 5, the court has observed that summoning of drawing officer of the company in which the wife is working is not relevant, as she has already produced the salary slip of December 2023. And as such, there is no necessity of summoning the drawing officer. The wife had joined only because the wife has joined service in 1994 and her present salary is shown as 38,000. It cannot be assumed that correct salary of the wife has been suppressed by her, since the correct salary certificate is already before the court. And later, if it is found that she has made some false submissions or the
Affidavit.
false statements, necessary action can be taken as per law. And hence, the court felt that there are no grounds to summon the drawing officer where the wife is working. Next paragraph. When counsel appearing for the husband submits that this is a second marriage for both to the wife and the husband. Through the first marriage, the wife has received the alimony.
4 lakh.
How much?
4 lakh. That also
Alimony-
suppressed. She never
alimony of
mentioned in
rupees 4 lakhs
assets and
that
liabilities.
was suppressed. She is having landed properties. That aspect was also
Please.
suppressed by the wife. According to the land council, a person who is working in a multinational company from the year 1994, 94, in 2025, she cannot say her salary is 34,000, 38,000. It is
She's a
submitted
team
that-
leader, madam.
One
She's a
minute,
team
please.
lead. Sorry, madam.
38,000. It is submitted that earlier, it is stated that her salary is
28,000, 29,000.
29,000. Now, as per the salary slip, that is 38,000, which shows that there is suppression and misrepresentation of facts on the part of the wife. Further, she is having landed properties, and also she lives in a palatial building. All these aspects are necessary, and the court, if the court summons the drawing officer, all the issues will come into light. It is submitted that the court ought not to have dismissed this application. Next paragraph. Having heard the learned counsel of the petitioner, there is the material on record. Admittedly, in this case, the wife has filed the income tax returns. The wife has filed the salary slip. It is the assumption of the petitioner that because she is working in an MNC from the year 1994, so her salary cannot be 38,000. As such, the drawing officer has to be summoned. The court, by giving a cogent and valid reasons, had dismissed the petition and has rightly held that when those documents are before the court, it is not necessary to summon the drawing officer. Further, if at any point of time any of the submissions, any of the documents that are placed are not a genuine documents, court would initiate appropriate steps as per law. In the considered opinion of this court, the order that is passed to the court is a well-considered one and no interference is called for, accordingly dismissed. Next.
Still number 32. Still number 32.
Yes. What is impugned order?
Let the impugned order is application rejected under section 24, seeking interment is by the wife.
Notice to respondent. Same, hand summons?
Yes.
Shall file a memo to that effect by 28th of August.
Please.
Yes, next, 33.
Still number 33. Maltese H for petitioner.
Husband's petition, my lord. Challenging, my lord, interim maintenance of rupees,
How
my
much
lord.
is awarded?
6,000, my lord, is awarded. And my lord, there is no, my lord, children. And my lord,
What is your income?
my lord, he is doing plumbing activities, my lord.
How much is your salary, plumbing activity?
My lord, he is,
20,000 per month minimum you will get.
my lord, he is not a contractor, my lord. He is a,
Are
he
we
helps,
talking about a plumber, a technical work?
my lord, not, my lord, daily, he doesn't have, my lord, daily work, my lord, and,
So according to you, what is the income?
my lord, he, my lord, earns, my lord, around, my lord, 800 rupees per day, 800 to 900.
So 800 into 3, 24,000. Or if not,
Not on every
at
week.
least we'll say 15 days. 15 days you're working.
Yes, my lord, but my lord, my lord, it depends, my lord. It depends, my lord. Every week, my lord, he.
For you, who is earning to say what is that you're earning, which is variable in a month. If you just don't say that and something like we can't read in between the lines.
Yes, my lord. But my lord, my instruction, my lord, that my lord, he is getting, my lord, 800 to 1,000 rupees, my lord, every day. And my lord, his work, my lord, he is not get the, my lord.
Even if you work for 20 days in a month, you will get, even if you work 15 days for a month, you will get 15,000.
Yes, my lord, there is chance, my lord.
That's not, there is nothing to consider in this petition. Let's see the order of the court.
Yes, my lord.
I think it's not even necessary to order notice in this. Yes, let's see.
My lord, Lakshmi kindly see, my lord, her application, my lord. My lord, she is staying in my home only.
Let's see. How the court has considered it, we'll see.
Yes.
Please read from point number 1.
Point number 1, on careful perusal of the material available on record, it appears to me that the petitioners have filed the petition under section 144 of BNSS, paying this court to pass an order directing the respondent to pay maintenance along with the petition. The petition has filed instant application praying to grant interim maintenance of rupees 1,90,000 per annum on the ground that the respondent has neglected the petitioner without providing day-to-day basic necessities.
You can come to paragraph 11.
11, my lord. The petitioner in her petition stated that the respondent is earning income from public work and used to receive rent from house and has capacity to pay the maintenance. My lord, the houses are in the name of, my lord, the ancestor, my lord, parent house. My lord, this income of his parents. Pay the maintenance, which is disputed by the respondent, contending that the petitioner father is having 7 acres of ancestral properties and earning sufficient source of income. The respondent has produced RTC extracts pertains to the landed property standing in the name of father of the respondent, but he has not produced
So
prima.
there is nothing to interfere with the order.
No, she's
6,000 is a basic amount.
not. My lord, she is, my lord, staying in the house belongs to the, my lord, she's living in matrimonial home only. She is living in, she admitted that she is living in the matrimonial home for the purpose of, my lord, getting the, my lord, the maintenance. She left the, my lord, she was doing some panchayat, my lord, the contract basis work. She joined the, my lord, the paramedical college. Now her application, lordship, may kindly see, my lord, in page number. Page number 80, my lord, annexure H. She is seeking, my lord, college expenses towards medical college expenses of rupees 1,20,000.
For whom?
She is claiming her inter-maintenance application in page number 80, annexure H.
She might be claiming, but the court has not granted. Court has granted.
Granted only 6,000.
6,000.
6,000 for his, my lord, for him, my lord, though she is, my lord, having all the capacity of, my lord, earning herself, and she was earning, left the job, and, my lord, joined the, my lord, the educational course, and, my lord, she is staying also, my lord, in the matrimonial home. For that, my lord,
Even if she's staying in the matrimonial home, she has to feed, I mean, herself, she has to eat, she has to buy the provisions. How much it will cost?
6,000 per
5,000 for 6,000 rupees in a month is a bare minimum for even for a village also.
But there is
People residing in the village.
No, my lord, it's not a village, my lord. It's a district, my lord, headquarters.
All the more reason it should be more than.
But
I'm talking about staying in a village.
Yes.
According to you, she's staying in the district headquarters.
Yes.
So the expenses will be more. Will not interfere with this. Please come. Agreed with the orders passed in. I number 2. In criminal miscellaneous number 120 of 2025 dated 7 July 2025, whereby the court has granted 6,000 as maintenance to the wife. The husband is before this court. The wife had filed the petition seeking maintenance of an amount of rupees 1,90,000 per annum, pending disposal of the petition. The wife has stated about the criminal cases that are pending before the parties, and also the capacity of the husband to pay the amount. According to the husband, he is doing the plumbing work and is earning his livelihood. And the husband has denied the fact that he's having any landed properties.
Can I permit you to withdraw, my lord?
Better.
Please.
Give a memo.
I will give
A
the
memo
memo.
is filed seeking to withdraw the petition, accordingly dismissed as withdrawn. Yes, next.
Number for admission, cell number 34, Mukkanappa, Ms. B for appellant, Patel D. Karagowda.
My lord, in MFA
Yes.
3783/2025,
and 3881 of
Who appears for
2025.
the respondent?
My lord,
Who is appearing for the insurance company?
my lord, not insurance, ECA matter, my lord, no insurance.
Oh, workman
No
compensation.
insurance. My lord, I have filed 2 appeals.
Like all these are all batch. We'll hear it, only one mark. We'll hear it in the afternoon.
My lord, one submission I have to make. In MFA 3783 of 2025, my lord, the other 3 respondents have deposited rupees 3,31,506 towards their share. I have to deposit rupees 2,21,000 and 4 rupees towards my share. It's a joint and several liability. I may be permitted to make deposit of that amount. For that,
What happened to this MFA of 2017?
my lord,
3806.
Huh?
3806,
and 3807 is my appeal.
We will
Whatever
hear
my
your
share
appeal.
is, I am deposited before this.
There are
We will
5.
hear that.
There are 5 respondents.
We'll hear his, no, 17 appeals we have to hear.
My lord, I may.
Yours is a fresh matter, 2025.
The same accident, same incident.
Who are you?
Lord, I am also one of the respondent, contesting respondent.
I understand.
Contractors.
What is,
I am a contractor.
you are a employee.
I am the employer, according to them. But
My lord, they have not deposited the complete amount. Only 3 portions they have deposited. I have also made deposit. Unless the complete deposit is made, appeals were not maintainable. My lord, I have to deposit my share also.
No, in 34 also you didn't deposit.
My lord?
In 34 you didn't deposit.
No, in both the cases, in MFA 3783 and 3881 of 2025, I have filed an application for permission to make deposit of my share. Yes, they have deposited their portion of share. So they let the amount be deposited, my lord. If I do not succeed, the claimant will get the money easily.
That's what I'm asking.
Yes.
In 34, whether the amount is deposited or not.
Portion of amount is deposited.
Oh, and as per law, what it should be done? That's portion only.
Yes.
Whoever is coming, whatever his liability, he has to deposit.
my lord, in trial court, my lord, the respondent number 1 and 2, 1 to 5, directed the 1 to 5 to deposit the
entire amount.
Entire amount.
That's
Yes,
that means.
I am filing the appeal on behalf of respondent number 1 to 3.
Let's see give the file. Let's see what is the order.
Lord, let my application may be allowed by giving permission to make.
1 minute, 1 minute. These are all connected. Let me
Connected,
just
ma'am.
understand
Yes.
what it is. Petitions in ECA 2000 so and so compensation.
Yes. 4 and 5.
Respondents 1 to 4 are directed to the within 2 months. Then how is it apportioned? The liability.
My lord, their deposit has been already accepted by this honorable court. They have permitted to. Yes.
This is the amount 5,52,000.
Yes.
I can understand respondent is 1. Respondents are 5 in number.
5 in number.
The court says that they are directed to pay the compensation within 2 months.
Yes.
My lord.
My
may I
lord, they
submit,
have
my lord?
deposited.
There are 5 respondents.
Yes.
The court has directed to deposit the
Jointly and
amount
severally.
Severally, my lord. So they have to deposit each
Entire
share.
amount.
Each share.
How can it be?
There are different people, my lord.
3,31,500.
There are 5 respondents. They are engineers. They are engineers. So now the 3 have filed this 3806. In that,
3,31,500.
they have deposited. The remaining the 2 have filed a separate case. That is the other connected matter. In that they have not
What I'm
deposited.
asking is, whenever a compensation to be awarded, what the court would say, respondent 1 to 3 are liable. If it is liable, what is the share of their liability would be considered.
Please,
If it is not, then each one is independently, jointly and severally. And if it is for the claimants to recover the amount, then whenever an appeal is filed, the entire amount has to be deposited then.
Court has accepted it, my lord, and court has given permission.
Which court has given permission?
This honorable court has given
Where is
permission
that order?
in their appeal.
Appeal number, sir.
256, sorry.
3806.
3806 and 3807.
3806 and 3807.
06 and 3807.
No, I am. Oh, why did you give 3783? I want 3806. That's what it is given. Where is the order sheet in this? What it said was appellants are permitted to deposit the amount before the court. The court has never said you deposit
They have filed application for that purpose only.
1/5.
They
Who
have-
said
they have
1/5
filed-
amount be deposited?
Yes, ma'am. Yes.
Where is
I
that?
filed the application also. See.
Then what is the purpose of asking the purpose of depositor? Please tell the date.
Long back in the year 17, my lord.
2017. 27/6/2017.
27/6,
2017.
2017.
Permitted appellant to deposit the amount.
2017, there is no such order. The appellants are permitted to deposit the award amount before this court is the only order.
I am the there are three appellants in my appeal, Manila, 3806 and 3807. There are 5 respondent in trial court.
Correct.
We are also the respondent in trial court. Can you run say 3806 in the trial court? The order passed by the trial.
Yes,
court.
Pradeep?
What happened?
No.
Please.
No. Now, the court says in a easy matter to deposit the amount, so and so is the amount. For example, 2 lakhs. Respondent 1 to 5 are liable to pay. Now, one respondent 1 will come, 4 and 5 will, the 2 to 5 will not come. Respondent 1 says, so 1 lakh so it is 20,000 is I have to pay, so I will deposit 20,000 amount. In the order does not say, then it is a complete liability, is it not?
It can't be say that part of the amount is mine.
So when the act says that you have to deposit entire amount or whatever is the amount that you have to deposit. Now there is nothing like you are liable to pay only this much. You are all joint and severally liable to pay. So when all are before the court has to apportion that this much, this one, and so in all the appeals, whoever is coming to the court, they have to they have to deposit the amount. So in your case, you 1/4 will not do.
The remaining amount I will deposit, my lord.
In all the cases.
In all the cases.
Though you are the respondent, you will deposit.
Yes, sir. That's why I have filed application. Remaining amount I will deposit.
In all the appeals.
In 2 appeals. In other appeals, so it is already deposited.
You are no.
ECF 4 and ECF 5.
No.
I have to deposit.
Let's not get MFA 3806. What is the amount deposited?
My lord, it's 3 lakh something.
What is the awarded amount?
Awarded amount, Your Honor, the 5,52,510 rupees.
52,000?
5,52,510 rupees. Here I am filed 3 appellants, Your Honor, filed this appeal. So is my share, Your Honor?
That's what I'm saying precisely. No share. When you file the appeal, whatever is the amount you have to pay, because court has never said your liability is only 1/4, or 1/3, nothing.
They earlier have filed an application.
That is not considered by the court.
My lord, anyway, I will deposit the remaining amount.
Remaining
complete the process.
That's what I'm asking. So let there be a clarity. You have deposited how much?
3 lakh. My lord, I have
I'm looking at MFA 3806.
Yes, sir. 3,31,506.
3,31,506.
Yes.
Then come to 3807.
In 38007, they have deposited
Each
3,81,322.
Yes.
3 lakh?
81,322.
81,000?
222.
220. What is the amount in this?
My lord, in
3807.
3807, the amount is 6,35,370.
6,35,370. Then coming to MFA 2566.
5 lakh.
That is not.
Yes, 5 lakh.
52,510.
5 lakh 52,510.
510 is the awarded amount.
Award amount.
How much is deposited?
3,31,506 they have deposited.
3,31,000.
506 they have deposited.
So same amount in 34 and 34.2.
Yes.
Because 34 also is at the same amount.
Yes.
Then 34.3.
My lord, some difference in amount. My lord,
pass over, please come up with the correct details. What is the
My
awarded
lord,
amount?
I have explained in my affidavit. My MFA may kindly be seen.
You have explained about every case.
Every case. 3783 of 25 may kindly be perused. MFA 3783 of 25, page number 47.
Page number?
47, 47. In the affidavit, I have
1 minute. 47.
Yes.
What did you say?
My lord, para number 3.
Para number?
3. My lord, respondent 3 to 5 in ECA 4 of 2014 have made the following deposit. Fourth column amount is 3,31,506. My lord, may kindly turn to page number 48. Para number 6. So total amount is ECA 4 of 2004 is rupees 5,52,510. P. Srikantamurthy and others, those 3 persons have deposited 3,31,506.
So this is with regard to 3806.
Yes.
And then about next?
Remaining.
3807.
My lord, 3881 of 2025 may kindly peruse.
3881
of 2025.
Please come. MFA. I'm not able to understand why you the MFA 3783. This could have filed in.
They have also challenged our liability, my lord.
The agreed by the award passed in, which is the award?
Same award.
What
Same
is
award.
the ECA number? 4. Agreed by the award passed in ECA number 4 of 2014. Which respondent you are before the trial court?
The respondent number 1 and 2.
I am the respondent number 1 to 3.
3783 of 25, respondent 1 and 2 have filed this appeal.
Trial court.
I am looking at MFA 3806. I am asking him which
3806.
respondent he is.
Yes.
3806 is respondent number 3 to 5.
I am the 3 to 5, Your Honor.
Respondent number 3 to 5 have filed MFA number 3806. In the said ECA, the amount awarded is 5,52,510 and they have deposited 3,31,506.
Yes.
And which respondent you are in the main ECA?
My lord, respondent number 1 and 2.
Respondent number 1 and 2 has filed MFA number 3783, questioning the very same award.
Yes.
It is submitted that the remaining amount of rupees
2,21,004. Para number 40, page number 48.
The remaining amount of rupees 2,21,004 will be deposited by the appellant in MFA number 3783, who is respondent in the ECA 1 and 2.
Yes.
1 and 2 within a period of
6 weeks, my lord. 6 weeks.
Why are you questioning this order in 2025?
My lord, earlier I have filed appeal without deposit. It was dismissed with liberty to file fresh appeal after making deposit.
So you have taken this much of sweet time. What happens to the the interest and all?
The interest I am liable to pay.
Has to pay the
Right
amount.
now, my lord, I will
the
deposit
amount shall
principal.
be
If I
paid.
do not succeed, I will pay the interest also. If I do not succeed in the appeal, I am liable to pay interest also.
Is it so?
Yes.
They
Principal
have to-
amount needs to be
Interest
deposited.
they have to deposit, my lord.
Pradeep, you are only here to assist the court. Don't think that your friends will.
Principal amount we need to deposit.
What is the procedure?
Award amount is called, my lord, with interest only.
With interest has to be paid. With interest, the remaining amount, the interest has to be calculated on this 2,21,004, and along with the interest, the amount has to be paid. Paid within a period of 4 weeks from today.
In connected
Or
appeals,
else the appeal, MFA number 3783 of 2025 shall stand dismissed.
34.3.
Accordingly, this IA is
MFA
ordered in MFA number 3783.
Yes.
Yes.
34.3, I accept notice to respond number 1 and 2.
What is your name?
Well, Harish NR.
Mr. Harish NR submits his instructions to file wakalat on behalf of?
Respond number 1 and 2 in 34.3 and
In 34.3.
34.4 ಅಲ್ಲಿ I respond 1
1
and
minute.
2.
In 34.3, 1 and 1, 2,
1 and 2.
1 and 2. And then?
3 dead, my lord. 3 dead.
Then in
On 5/10/2022, 3 dead.
34.4.
30, my lord, 1 and 2.
Again, in 34.2, Mr. Harish has instructions to file wakalat on so and so. Yes.
My lord, respondent number 3 died, my lord. 34.3, respondent number 3 died. It is also already reported in connected matter.
It is submitted that respondent number 3 died in
On 5/10
34.3 and 34.4.
34.4 LL, 34.3.
34.3, respondent number 3 died and the same is communicated to the appellant, comes for the appellant on?
Please, 5/10/2022 he died. It is already, they have knowledge of the death, my lord, because in connected.
And when did you communicate that?
My lord, in connected appeal is communicated. They reported.
It's already, the appropriate step shall be taken by the next date of hearing.
46.
Yes.
46.
We'll have it.
In 3881, in 3881 of 2025, my lord, I have to deposit rupees. So
Give the cause list.
I have to deposit rupees.
In which case?
That 3881 of 2025. I have to deposit rupees 2,54,148.
2,54,000? Yes. Same. And array of respondents are same.
Yes.
Same like in the other order, in 34.4, they have to deposit 2,54,148 with interest within 4 weeks, or else the appeal shall stand dismissed.
35, my lord. Next matter,
35, I bring for respondent.
Next matter, my lord, connected case. Owner in first case is served. Second case is endorsement shows that he is dead, my lord. I will verify and take necessary steps.
Use that.
35.
My lords,
Pauses.
mentioning my lords,
There it is.
my ladyship serial number 43.
No adjournments, please don't
And
make
one more
mention.
submission,
now.
my lord, deposit before this honorable
pending
court.
before the
Before deposit before this honorable court.
Where it is done generally,
In another case also, they have deposited before
then
this.
before this court only deposit. Then 35, what were you asking? 35.1?
5.2, one, my lord. Owner is reported to be dead, my lords, as per the personal endorsement. In first case, he is served. In second case, my lords, it shows that endorsement is dead. I will verify, my lord.
In 35.1, as per the office endorsement, as per the postal shara, respondent number 1 is no more.
One is no more.
1 is no more. And the land counsel for the appellant submits that he'll take steps. This is matter after 2 weeks.
Records may be called for.
Call for the records.
Ladyship serial number 43, counsel for the respondent have some matters clashing. Small adjournment, ladyship, please. Would be grateful.
Please understand, it is so embarrassing for the court to reject the advocate's request when I specifically say, print in the cause list that there are no mentions at 1:30.
I did wait, but just that.
No, you have to wait till the matter reaches, or your colleague should be here. At the request of, have you informed the petitioner's counsel?
I'm trying to locate them.
No,
I will
no,
do it. I will do it.
That we will
ladyship,
not
please.
allow. It has to be informed and then only should be made mention. Yes.
ಅದು ಸ್ಲಿಪ್ ಅಲ್ಲೇ ಇಟ್ಟಿದ್ದೀನಿ.
ಇವ್ರು ಸಣ್ಣ ಕೊಡ್ತೀರಾ ಇದೊಂದು ಪೆಂಡಿಂಗ್ ಉಳ್ಕೊತಾರೆ ನನ್ನ ಕಡೆ.
ಇನ್ನತ್ರ ಅಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಉಳ್ಕತ್ತ ಇದು ಯಾವ್ದೋ ಒಂದು ಡೇಟ್ಗೆ ಸ್ಕೂಟ್ರಿಗೆ ಹೋಗ್ಬೇಕು. ಈ ಭಾಸ್ಕರ್ ಮಾಡೇ ಇಲ್ಲ. ದಿನ ಹೋಗೋದು ಏನಿದು ಇಲ್ಲೇನೋ ಬರ್ದಿದ್ಯಲ್ಲ?
ನಾನು
ಪೆನ್ಸಿಲ್ ಅಲ್ಲಿ ಯಾರು ಬರ್ದಿದ್ದು? ಮೇಡಮ್ ಏನೋ ನನ್ನ ಲಿಸ್ಟಲ್ಲಿ ಬರ್ಕೊಂಡು ಅಲ್ಲಿ
see password. Until is the list.
Cell number 36, KL Srinivas for petitioner. Cell number 36.
Where is the other side? Somashekar. You are Srinivas.
Home Shekhar
And you
Kashinath.
submitted that there is a likelihood of settlement. There is no representation on behalf of the land counsel for the husband. The parties are directed to give 13th of August. Yes. That mic is not working. Oh, there is one more to say.
I am going to submit this before final approval. The petitioner is filed. The respondent also filed any petitions.
Before you go to any 21/3/2025, an interim order is passed.
Yes, Your Lordship.
So what has happened to the interim order? Have you complied with the interim order dated 21/3?
No, Your Lordship, I need to pay the amount.
Huh?
I need to pay the amount. The
No,
petitioner,
it's only one answer.
Yes.
Have you complied, not complied? Not complied.
Due-
If
due
you
to
are
the
not
reason-
complied, we will vacate the interim order.
no, Your Lordship, I am ready to pay the amount.
Pay.
Just
Who stopped you?
give me the one opportunity to settle the matter. That's it.
What
I'm
is the
giving-
settlement? What is the settlement?
The petitioner is ready to pay in 5 lakhs
What is
rupees, Your
that?
Lordship.
5 lakhs rupees.
Yeah.
No, there are arrears. When is the application filed seeking maintenance?
Your Lordship, in MMTC 1, they have filed an application. The application is in favor of the petitioner.
I'm asking when is that application?
My application is on
2012 was a petition filed. It is disposed of when? 13/6? Thereafter, no, for the arrears which you need to pay 12 lakhs, she will agree for 5 lakhs.
Your Lordship is not working also, Your Lordship.
What is he doing?
He is in insurance company, Your Lordship. Insurance
What is
company.
his age?
46, Your Lordship.
And he is not working.
Not working.
Why?
There is no any job, Your Lordship. He is searching for the job. From last year, they are not getting their job, Your Lordship.
Please come.
So
On 21/3/2025,
I'm
an
right.
interim order was
One-
granted
One opportunity will be given for the mediation, Lordship. If it is a settled,
to
Lordship,
pay the amount, some amount right now, but I'll list this matter tomorrow. You pay the amount, some substantial amount,
Yes, Your
then we will
Lordship.
think about the mediation.
Oblige, Your Lordship.
Tomorrow, list this matter tomorrow.
Oblige, Your Lordship.
By the time, the petitioner shall pay the amount, some substantial amounts to the wife, or else the stay granted by this court stands vacated. Tomorrow,
Oblige, Your Lordship.
yes,
Heading in B group, serial number 39.
yes.
I'm appearing for the petitioner, Malda. That husband writ petition, Malda.
What is the amount granted?
No, Malda. What had happened, Malda? The petitioner filed the divorce petition before the trial court, Malda. 13(1)(a), Malda. And the respondent, Malda, appeared and filed the statement of objection.
Impugned order is dated?
In impugned order, Malda, your lordship may kind residing with me, Malda.
By way of
She-
this,
she
by way
asked-
of this IA, by way of this IA, what you wanted, what is the relief sought by the father?
What the trial court has permitted and directed the headmaster, Malda, to permit the respondent see the child in school premises. What my submission is that, Malda, since long back, that child is far away from the mother, Malda. She is the 4-year child is residing with father, Malda. Some of the communication that, Malda, there are long gap between the mother and child, Malda. If she is want to see the child, Malda, she seeking direction to headmaster to permit to see the child in school premises, Malda. That was not correct. If they, in case, Malda, she filed the JNWC for the seeing the children, Malda, she made an application for 151 CPC in divorce petition, and she has claimed, counterclaim that under section 9, Malda. Even notice has been served, Malda, she has not come up before this court, Malda. So my submission is that, Malda, it is not permissible in the school premises, in the absence of the father, she go and see the child, Malda. It is very affect the future, that life of that daughter, Malda. Education, they disturb the education, Malda. Therefore, Malda, that application is not order passed by the trial court is an impugned order, Malda, not sustainable. If she is seeing the child, Malda, she filed separate petition.
Wife, the mother had not filed any petition seeking custody of the child, nor any petition is filed seeking in the said application. She has not initiated any proceedings on the Guardianship and Wards Act. It is submitted that in MC she cannot file an application to see the child in a school when the child is not comfortable with the mother and she has been residing with the father. It is not permissible for the court to pass such an order. This court has perused the order passed by the court. The court, while granting the visitation at paragraph number 6, has observed that the husband disputed that if the mother visits the child, it would have an adverse impact upon the daughter. The court has observed that it is needless to observe that every child is having right to have motherly love, and at any cost that natural motherly love and affection cannot be taken away by anybody on any grounds. Therefore, the court has granted the visitation rights, keeping in mind the welfare and development of the daughter in all aspects. And the wife had made out sufficient grounds to consider the application. Next, notice is served on the respondent, but no wakalat is filed. This court, by order dated so and so, has held notice to the respondent sufficient as a deemed service of notice by any of the contention that are raised on behalf of the husband. The court had granted a supervised visitation in the school premises. It cannot be said that the child if the meeting the mother in the school would have an impact on the life of the child. And the court had rightly observed that what is the necessity of a motherly love to the daughter. Then coming to the application, for the visitation, no application can be filed under the MC. This also has no legs to stand. And the court had rightly, under the circumstances, had rightly considered and granted the visitation, and this court finds no reasons to interfere. Dismissed. Yes, next.
Cell number 40. Cell number 40.
For petitioner, my lord.
Yes.
Lord,
Yes. Where is impugned order?
Lordship,
Impugned order, where is page number?
page, page number 18, my lord.
Dismissed.
70? Thank you, sir. Petition. Who filed the MC?
I filed petition.
Husband filed.
Husband.
So what is to be considered now?
My lord, I filed objection on IA number 3, which without considering my IA 3, they have made an order.
What to do? You don't come to the court.
My lordship,
Read the order.
my lord,
Read the
here,
order at page number 26. Start reading from the starting.
again it called out and petitioner and counsel are absent, no representation made and counsel, respondent and the counsel are present. Counsel for respondent files a memo stating that, yes, filed affidavit of assets and liabilities on 15/3/2021, and that respondent has lost the job on account of COVID and is not in the position to bear education expense of their minor child. Order sheet as of the said dated disclosed, and the respondent has filed affidavit of assets and liabilities on the said date. Counsel for a petitioner absent. Cost not paid. Hence, objection to the IA3 by the petitioner is not has not filed, and
So-
affidavit of compliance has also been not filed.
On cost, you are directed.
Been filed much before that, madam, my lord. This is what in page number 22, one paragraph, I will just read it out, my lord. Advocate for petitioner presents and files objection to IA number 3, along with IA number 4 under the section 151 of CPC. The for objection on IA,
Where are you reading?
page 23, my lord.
Hmm.
That last paragraph,
Hmm.
it says that advocate for petitioner presents and files objection to IA number 3, along with IA 4 under section 151 of CPC, my lord.
Then what does this order mean set on 18/9/21?
My lordship, this we have filed. They are, one other side, it is saying that I am not filed. They have not given a chance for me for hearing, and they have passed the order. And respondent filed a memo stating that she is not working, and based on that,
What happened to this MC of 19? What is the state?
lordship, further evidence.
Switch on the mic. Which court is this? Please come. What about the payments? Any interim order is passed by this court?
My lordship, that interim order, what it is where we have complained, and
Interim order.
my health also is not in a good conditions. And I have also filed assets and liabilities after the order has been dated. So they have filed wrong, they have done a wrong submission stating that I am doing real estate, I'm doing extra work. But the thing is, I am a daily wages, I am a silversmith. I work for one shop where they do a silver articles. So based on that, I have told my salary is not so much, and I also filed affidavit. But they have come to a conclusion that my salary is different, my lord. That is what, and I had to take care of myself because my health is not good, and I also have mother. I had to take care of myself because my health is not good, and I also have mother. So based on that, and respondent is working for one government company, and she is taking care of herself and the child, son, who is around 17 years. So this is my, so, and because due to my health condition, I'm not able to work, and I have been taken a rest, and I'm
Yes,
not
what
doing.
you said? I'm not able to hear what you're saying. Page number?
Page number 71, Your Lordship. It's an assets and liability filed by the petitioner herein.
Yes.
Kindly peruse the last but second line, Your Honor.
Of which page?
71 only. Page number 71. In page number annexure, something they have not.
Two people, it would be 30,000.
It might be that
So,
that
no,
might be a
no.
calculation.
So that for it has to be, court has to give 30,000 to the wife. What is that calculation?
No idea. That is my assumption. It's what it's my telling. It's my
Yes,
assumption.
yes.
Before that, has my learned friend made some submissions? He is nowhere working like that. He's a political leader in the local. For all those things, I have established in the trial court. I have filed original photos in therein. I have few photographs with.
Political, if it's a political leader, it gives money or salary also.
Yes, he is definitely getting some huge amount last year. He has a very good cordial relationship with present. I do not make my submissions, but still he has a very good cordial relationship with the present cabinet ministers. That much he is capable, and he is having a sufficient amount. He is a karate master, and he's having a book vendor, and he's running a book vendor, seconds book vendor he's running. And addition to that, he's a very good goldsmith. And he's telling, has in the first paragraph, in the first page, he was telling that he was a worker at silver shop. But when it comes to his earnings capacity, he disclosed before the December court that at page number 1 second. At page number 70, page number, again there is 73, is the 74, I think so, Ilash. 74, Ilash. Here, column number F3, his wife and minor child, Ilash. This is what my humble submission, sir.
My lordship, final political, all that, we don't have any such.
What is that? How will the court consider all that? That's the submission.
15,000
court,
income is
agreed
there,
by
they have
the
ordered
passed
30.
in- Passed by the court, whereby the court had granted, passed by the court in MC number 5017 of 2019, E9 number 3, whereby the court had granted, whereby the court has directed the husband to pay the educational expenses of the minor child to a tune of 20,000 per month, and also to pay interim maintenance of 10,000 per month to the wife from the date of the order till disposal of the petition. The husband is before this court. Then counsel appearing for the husband submits that they have filed their objections, the statement of assets and liabilities to show what is the financial capacity of the husband. Without considering all that, the court has passed the order. He has drawn the attention of the court to the proceedings dated 8/9/2021, where the court has recorded that not that day, some other day. On 16, on 8/7/2021, where the court has observed that the advocate for the petitioner present and files objections to I number 3 along with I number 4 under section 151 CPC. For objections to I number 4 and to hear on I number submitted that the said amount is granted without any basis. When counsel appearing for the respondent wife submits that the husband has suppressed several factors. Is doing, according to him, is a karate teacher, he is a book vendor, he is a politician, and he is working in a silver shop. Doing all this is he is deriving a lot of income, and these aspects were suppressed by the husband. He draws attention of the court to the statement of assets and liabilities. According to them, his personal, he requires 16,000 towards the personal expenses. If one person requires 16,000 as personal expenses, two people will require 30,000. Then, with regard to the income, he has stated that he has no fixed income. When he says that he has no fixed income, that amounts to that will strengthen the case of the wife that he is doing business. It is submitted that under these circumstances, court had rightly granted the maintenance and there are no grounds to interfere. Next paragraph. Having heard the counsels on either side, peruse the material on record. This is an MC filed in the year 2019. Now the matter is at the stage of evidence. As far as the interim application for maintenance is concerned, the court has simply said 20,000 per month towards expenses and 10,000 towards 10,000 to be paid towards maintenance. The monthly expenses is on the higher side, and that apart, this is an MC of 2019. The case is pending on the file of the 4th Additional Principal Judge Family Court. As a family court, so disposing of the matters of 2019, this court deems it appropriate to direct the family court to dispose of this MC itself by 15th of December. The pending consideration of the MC and the final orders to be passed, the husband shall pay the interim maintenance at 10,000 from the date of petition till disposal of the case.
15,000 maybe awarded.
Accordingly,
Minus son is there.
and about the entitlement of the educational expenses and other things, basing on the evidence, the court shall pass orders in the main petition. Yes.
The number 41.
Publish, please.
Serial number 41.
In serial number
41 appear for the first petition, 41 appear for the respondent, my lord. 41.1, 41.2 appear for the petitioner, my lord.
Yes.
There are three written.
I am for respondent husband in serial number 41.1 and serial number 41.2.
No, I can understand. It is not so complicated. Yes.
My lord, the husband herein has filed the divorce petition before the trial court, my lord,
So,
on the grounds of desertion.
What is your petition?
My lord,
Interim maintenance is question.
no interim maintenance, my lord.
Then what is petition?
IA number 6 filed under order. IA number 6 filed under order 6 rule 17.
Let's see that. Please come to the impugned order. Let's read this order. What are the two? What is impugned in 4642?
My lord, in 41.1, that is WP 47, 46, 42, but
41.1 and 2. I am for the petitioner. I am, if
let me
Lord
complete.
permits me, I may be permitted to address my argument as a petitioner.
No, I'm only asking him what is the writ petition for, because he's before the court. It's easy for the court to understand. Yes, 4642, what is it?
That is the impugned order in page number 193 to 203, my lord. I have filed IA under order 1 rule 10 subclass 2 to implead one Hemant Kumar under 1 class 2 to implead one Hemant Kumar under 1 Shiv Kumar to add as additional parties, my lord, in order to prove my allegations in respect of the adultery, my lord. That came to be allowed by the trial court, my lord.
The next one.
And in 41.2, I have filed IA number 6 under order 6 rule 17 to incorporate additional paragraphs in para number 15.1, 15A to 15I, my lord, in respect of the in respect of proving the adultery grounds, my lord.
First come to 41.2. Give 41.2. Let him argue on amendment. Yes, Mr. Counsel, 41.2.
41.2, Milord.
Where
Milord,
is the impeach order?
he has filed two applications to implead. First one filed by the petitioner husband against the respondent, filed by the petitioner husband against the respondent wife under section 13(1)(I) so and so Hindu Marriage Act 1955, seeking a decree for divorce on the ground of adultery, cruelty, and desertion. Adultery was in the main petition. There was no adultery, my lord, only cruelty and desertion in the main petition. After conclusion of the evidence of the petitioner's side, and when the cross-examination of RW1 was in halfway, the petitioner has come up with the present application seeking leave to amend the petition so as to incorporate additional para number 15A to 15J by narrating the fact that the respondent is having extramarital relationship with some persons, and also by narrating certain subsequent incidents of matrimonial cruelty meted out to him
So
by the
before we
respondent.
go into that, where is the IA? IA petition?
IA.
IA, where is that application?
Application, my lord, at page number at page
Affidavit?
number 185, my lord. 185.
We'll go to the affidavit.
Affidavit.
Yes, read the affidavit.
Affidavit at page number 189, my lord. 189. I, Sridhar so and so and so and so, I submit that I am the petitioner in the above. I submit that governments were so and so. Para number 3. I submit that I have filed instant case for decree of divorce. I have filed instant case on the grounds of desertion, cruelty, and adultery. Adultery was not in the petition, my lord. It is only here it has having illicit relationship with active with the above persons in MC number 59 of 2018 on the file of senior civil judge and at Chamraj Nagar as narrated amended paras. Hence, adding averments with regard to the adulterous life of the respondent is essential in order to prove my case. I submit that after filing this petition, I was subjected to cruelty by the hands of the respondent narrated amendment paras. Hence, adding averments with regard to the so and so respondent narrated amended para very essential to prove my case. It is submitted that since intending amended paras are subsequent developments after filing the instant
So,
case.
by way of this amendment, you're seeking only amendment of the pleadings, but not the prayer.
Milord,
You are not seeking amendment of the prayer.
Milord, in my prayer, the petition, kindly see the in page number 108, Milord. That is annexure D. Annexure D, 108. The petition itself filed under sections 13 subclass 1, 1A, 1B, and I of the Hindu Marriage Act, Milord. So in petition itself, I have filed the petition before the trial court on the grounds of desertion, cruelty, and adultery, Milord.
No.
Let's see.
In the petition, there is no adultery.
108, annexure
Not
D,
mentioned. No whisper.
Yes. Let's see, where are the allegations of adultery in this petition? In the original petition, in which paragraph you have attributed?
May I read, Milord?
Paragraph number 5, where did you say that it is adultery? That she's living adulterous life. Where did you say?
Milord, it is submitted that after the marriage, both petitioner and respondent started their matrimonial life at Mysore, and the petitioner has got aged mother expect her. There is nobody in the matrimonial home. In spite of it, the respondent is continuously harassing the petitioner for one or the other reason and made the matrimonial home as hell. The respondent gave a birth to a male child, 18/2014, who is now named Purvaj. In the month of June 2013, the respondent told the petitioner that she had conceived. On that day, the petitioner was very tired, was suffering from severe headache, and wanted to sleep early. But the respondent went on harassing the petitioner the whole night. It seems as though the respondent was under some fear. She kept on asking the petitioner why he was not happy, and he doubting whether the child was not his, though the petitioner did not state so. Unable to bear the torture, the petitioner went out of the house. My lord, here in
That is, you are not attributing anything.
In
You
my-
are only trying to say in this paragraph that there is cruelty on the part of the wife. Without a reason, she is harassing you. The next para, where did you say?
Para number 15, my lord.
Yes.
It is submitted that the petitioner was perplexed at the behavior of the respondent and decided to find out the reason for the unreasonable behavior of the respondent. On inquiry, he came to know that the respondent had run away with some guy before the marriage. She was brought back and married off the petitioner. When the petitioner inquired with the respondent,
Particular thing, I've come to know these facts were not in my notice. Particular thing, I've come to know these facts were not in my notice. So that's why I want to file an amendment petition. No. And your suggestion to her, because she said they are relatives on one time and friends one time, is it a ground to attribute adultery to her? And what are these reasons? And how can the petition be allowed after the respondent's, your evidence was over and the respondent's cross-examination stage?
she also admits that she don't have any impediment to implead additional paras, my lord. It is there, my lord. Kindly see the cross-examination portion of the RW1, my lord. She has admitted during the cross-exam in the witness box.
Her admission will not give you any right to file whatever you want at that stage. That is one aspect.
She admits
Then
that she did
amendment
not have
of-
any
that is-
impediment to implead the additional paras in order to prove the adultery.
The
license.
cross-examination that will be decided. For that, you will file an affidavit, you will file an IA, she will file her objection, there we will consider.
My lord, in my
What-
affidavit, I have clearly stated that
That I have seen.
after
So-
filing the petition, by way of inquiry, I am
Please, what is that inquiry? When is the petition? When is the inquiry? Please tell from your affidavit, let the court understand.
my lord, in para number 4, my lord,
Yes, page
I
number.
submit that in page number 189, I submit that after filing this petition,
When you have filed the petition? You have filed the petition which year? Which year is the petition? MC is
2000.
filed in which year? MC is of the year 2021.
yes, my lord.
21, that was transferred. Earlier, it was filed, my lord, in Chamarajnagar. That is in the year 2019. That was
Yes.
2000.
Ground to the court that this application can be allowed, will consider. Read that. Affidavit. Ground to the court that this application can be allowed, will consider. Read that. Affidavit.
My lord,
Entire
para number
affidavit
3,
you
my
read.
lord. I
No,
submit
not only
that
paragraph now. Yes, read paragraph number 3.
I have filed instant case for decree of divorce. I have filed instant case on the grounds of desertion, cruelty and adultery. I further submit that respondent living in adulterous life prior to marriage and after the marriage. The respondent having illicit relationship with Hemant Kumar, so and
You have
so.
taken 3 people's name.
My lord?
You have taken 3 persons' name.
Yes, my lord.
Hmm.
Another one is Shiv Kumar and
I've seen-
Abhishek, my lord.
Leave that, leave that. Yes, during cross-examination of PW1 dated, read from there.
During the cross-examination dated PW1 25/2020 in MC number 59/2016 on the file of the senior civil judge at JMFC at Chamarajnagar on confrontation, exhibit R2 to R7 got marked, my lord.
1 minute, what is this MC 59?
That is the petition filed by the wife for the release of.
Initially, he filed and he withdrawn it.
been allowed,
It was
but-
dismissal for non-prosecution.
Let me complete, sir.
That was filed in Mysore, 2016. MC for divorce on the ground of cruelty and desertion. That was dismissed for non-prosecution.
I am not submitting that. My lord, the
What is this MC 59 of 2006? That's what I'm asking him.
Yes, my lord. That's what.
He, according to him, it is restitution of conjugal rights.
No. What?
Read further.
1 second. My lord, 1 second.
MC in the year 2019.
My lord, this
So-
cross-examination taken place during the year 2020, my lord.
2020, still we'll take it as 2020.
20.
So what made you to file a petition in the year 2023?
My lord,
You have filed this IA in 2023.
my lord,
11/10/2022 is the IA.
along with objection statement, I have produced the deposition of the PW1 in MC number 59/2016, my lord.
Yes, Mr. Counsel, I understood the case.
In the year
Yes.
2022, my lord.
According to you, PW1's cross-examination in the earlier MC was on 25/2020. You filed the MC in 2020 for this divorce MC.
Yes, ma'am.
In 2020. This IA you filed in the year 2023. Trial has commenced. Now, according to you, though these things are not in your knowledge or before commencement of the trial, you couldn't bring all these facts to the notice of the court. But it is evident that you could have brought all this much before the trial has commenced.
My lord, my respectful submission before this honorable court. During the cross-examination of PW1 in MC number 59/2016.
When is that?
In the year 2021, 31/7/2021.
Right. 31/7?
2021.
When is this petition is filed? 11/10/2022. 11/10/2022. Wherever and whenever you want, pleadings cannot be pleading. You can't amend the pleadings. Yes, this is one. What the orders passed in? IA number. What are the IA numbers? Please tell. In the first case, what is IA? 23502. IA number 5.
IA number 25.
No. This 25810. What is IA? IA number
5, my lord.
IA number 5. This is filed
for conducting the DNA test.
DNA test. Then order 1 rule 10 is IA number
7, my lord.
Then amendment is
IA number 6.
IA number
6, my lord.
What happened to the restitution petition?
That has been challenged before this honorable court.
That's
By
allowed.
filing the MFA. It has been
Allowed.
admitted, my lord.
Yes.
I
yes.
filed.
It has been admitted.
Agreed with the orders passed in IA number 5. IA number all are same date.
No, my lord. This
Then
IA,
independent orders. So take this one I'll dictate first. Agreed with orders passed in IA number 6 in MC number 59 of 2016 dated 12th September 2022, whereby an application that is filed by the husband under order 6 rule 17 to amend the pleadings is allowed. Against that, the wife is before this court. Where is impugned order?
my lord, one submission.
Hmm.
Delay is not material, my lord. This is
That
the
I can-
continuous cause of action, my lord.
No, that I will record. All what you have argued, not argued, I'll
If
record
this-
in the order.
If this paragraph's not added, I'm very difficult to the petitioner.
Everything, now if I don't add anything that you can tell, I will again add those submissions. 4/2/2023, the wife is before this court. The facts of the case are, initially, the wife had filed MC number 59 of 2016 on the file of the senior civil judge and JMFC of Chamarajnagar seeking restitution of conjugal rights. That came to be allowed and the matter is carried in appeal and the same is pending consideration before this court. The husband has filed MC
MFA 8083, my lord.
MFA
8083, but 2020.
883
8083.
83 of
2022.
2022 and the same is pending consideration. The husband initially has filed the MC in the year 2019. Later, the same was
It is MC 102 of 2018, my lord. MC 102 of 2018
102 of
at
2018
Chamarajnagar.
is filed at
At
Chamarajnagar.
Chamarajnagar.
What happened to that?
Then that was transferred to Mysore.
Then that
Now
was
it is in
transferred to the second additional family court, Mysore, and renumbered
renumbered
as MC number
MC
539 of 2021.
21.
The MC is filed. Where is the petition? You said in this in favor of the petitioner. Prayer, you will not. You don't have to tell the section.
My lord, in cost total, I have put it, my lord.
In the memorandum of petition, it is stated that the petition is filed under section 13(1), 1A, 1B, and I of the Hindu Marriage Act. That is on the ground of desertion,
Cruelty and adultery. my lord.
adultery. Then when the matter is at the stage of when after After the wife is cross-examined in part, at that stage, 3 applications came to be filed. One is I number 5, stating that the daughter which is born in the wedlock is not the wife is living in adultery, and he is not the biological father of the child. As such, a DNA test to be conducted. Then IA number 7 under Order 1 Rule 10 to implead 2 persons who are having illicit relationship according to the husband to be impleaded and the third one is IA number 6, that is the which is impugned in this writ petition, IA number 6, where the he has sought for an amendment to add certain paragraphs by incorporating the names of those persons with whom the wife is having illicit relationship, and the child is not the biological father of partial the evidence already on record and also the particulars of proposed amendment. Since the case itself is filed for divorce on the ground of adultery also, it appears that the facts such as the wife having extramarital relationship with some other persons sought to be incorporated by way of proposed amendment is very much necessary for the purpose of determining the real question in controversy between the parties. Further, the alleged subsequent acts of the wife, which tantamount to matrimonial cruelty, are also relevant for the adjudication of the divorce petition, which is also filed on the ground of cruelty. Hence, the court felt that the petitioner has made out a grounds to permit him to amend the petition, and court had also considered the judgment of the apex court, the Supreme Court of India versus Vidya Bai versus Padmalata, civil appeal number 7251 of 2008, and then the judgments of the Bombay High Court and the Allahabad High Court. And hence the court has come to the conclusion that the proposed amendments are necessary for the purpose of determining the real question in controversy between the parties. And if the application is not allowed, then the husband will be put to untold hardship, as he will be totally prevented from producing some material particulars regarding the alleged act of adultery and cruelty by the wife. In such an eventuality, the injury that may be caused to the husband cannot be compensated in monetary terms. On the other hand, the inconvenience, if it is submitted that none of these grounds are satisfied, and at the fag end of the trial, the court cannot allow such an application, and the same is bad in law. Next para. When counsel appearing for the respondent husband submits that he has filed the petition seeking divorce on the count of desertion, cruelty, and adultery. And in the petition, he has stated that the wife is living in an adulterous relationship. But he submitted that the wife had filed a petition seeking restitution of conjugal rights. That is MC number 59 of 2006. And in the said MC, in the cross-examination of the wife, dated 25/2020, when she was confronted with exhibit R2 and R7, where the persons with whom she is having a relationship or relationships are there in the said picture, and he has suggested that the wife is having illicit relationship with the person, and she has stated that they are his one time as friends, the other as relatives, which shows that she is having an illicit relationship. As such, the husband has come up with the petition seeking amendment of the. It is not maintainable. Such a stand is already taken by the. It is not maintainable. Such a stand is already taken by the wife. In those circumstances, if this petition is not allowed, it would cause a lot of hardship. Court had rightly considered all these aspects. He further submits that mere delay in filing the petition cannot be a ground, and on technical grounds, courts cannot dismiss the application seeking amendment of the plaint. It is also submitted that in the pleadings, there is already a foundation with regard to the adultery, cruelty, and desertion. Now, by way of this petition, he is not introducing any and new case. And as he has come to know about these people recently, they were made as parties to this petition. If this amendment is allowed, no hardship would be caused to the wife, but if the same is not allowed, it would cause irreparable loss and loss to the husband. It is submitted that the court had rightly considered and allowed the petition, and there are no grounds to interfere. Anything else?
My lord, the adulterers, they have not challenged the petition. They have not made as party. Till today, they are not challenged, my lord.
You said so. You said in the cross-examination, they have raised that it is not maintainable. That's what I recorded. They have raised a ground.
Yes.
That's what I said. You said in the cross-exam, in the time of evidence, they said this petition is not maintainable without making those people as parties.
Their count
is not he is not the biological father of the child in the original petition. Now, by way of this amendment, he wants to add that she is living in an adulterous relationship with so and so, and the child is not born to him. According to this court has perused the affidavit that is filed by the husband. It is very important to look at paragraph number 3, 4, and 5 of the affidavit. Extract this, page number 189 in this one, in same WP. So, even as for the said application affidavit that is filed, he has stated that he has come to know about these people as he has cross-examined the wife in the restitution in the restitution of conjugal rights petition on 25/2020. So why he has not made them parties, and this present application is filed on 11/10/2022. That is not stated in the application. Then even in the paragraphs that are to be added in that also, when he has come to know how it is, why he has not seen from 2018 till 2023. After 5 years, he has come up with this petition. It is a contention that delay cannot be a ground. And it is also settled that court cannot look at court has to look at the substantial justice to be rendered to the parties, but not on hyper-technical grounds. Court cannot dismiss the amendment. While allowing an application for amendment, court has to balance the interest of both the parties. The petitioner altogether, the plaintiff, the petitioner cannot be permitted, a party who has come up with the amendment cannot be permitted to raise altogether a new ground. With regard to the girl, that she is not the biological father, it was never his case in the original petition. Now, by virtue of this amendment, he wants to add those paragraphs, and the trial has commenced long back. Why he is moving this application in 2022? There are no grounds except stating that as on the date of filing of the petition, that is 2018, these grounds are not known to him. But these grounds are as well known to him in the year 2020. And still he has not done anything. And in the cross-examination, when it is suggested that such an application is not maintainable without the petition has to be dismissed on the ground that the facts which are in the knowledge of the husband in the year 2020, where after the commencement of the trial, after the cross-examination, part of the cross-examination of the wife, that is the respondent, is has commenced. That time, nearly after 2 years, nearly after he came to know about this, according to him, on 25/2020, and the application is filed on 11/1/2020 on that ground. Second, when he is fighting a litigation, fighting a suit, fighting an MC, seeking divorce on the ground of adultery, without making the adulterer as a party to the proceedings for about 5 years, 4 years, he cannot be, by way of an amendment, he cannot be permitted to get over with with the same. And in the considered opinion of the court, the trial court, the family court, had failed to consider all these aspects, and more looking at what is the injustice to one side, has failed to consider what would be the injustice caused to the respondent, and allowed this petition. In that view of the same, the order dated uh, the order dated 4/2/2023 is set aside, and the writ petition is allowed. Take the next writ petition. Dismissed IA number dismissed IA number 6, that is filed by the husband, seeking amendment of the pleadings, wherein it is stated that the wife is having relationship with two people. Now, by order, by now, this IA number 7 is filed under Order 1, Rule 10, to implead those persons. The court, by order impugned, had allowed the application. Where is that page number?
Impugned order in 4642, sir. Page number.
Where is that?
One 190, my lord.
It is not
Impugned order at 193.
It is 196, sir.
3, 194, 195.
By way of this application, the husband want to implead one Sri Hemant Kumar Ji and Shiva Kumar as respondents 2 and 3. The court had allowed this application, holding that since the petition is filed under section 13(1)(I) of the Hindu Marriage Act, since there is a specific contention that the proposed respondents are adulterers, as they are having illegal relationship with the wife, as per the ratio laid down in ILR 2004 Karnataka. The affidavit is filed, application is filed on 13/1/20. Date is 11/10/2022. It is stated that at the time of filing the case, he was not having the material to add the persons as necessary respondent. Same in the other case, that restitution he has filed on so and so. This application is filed on so and so. And in the entire pleadings, there is nothing stated so and so. And this court has already dismissed the dismissed WP number 4711 of 2023, where an amendment is ordered by IA number 6, and this court has already dismissed that IA number 6 as not maintainable by order dated today's order so and so. In the light of the same, this application, this IA also cannot be allowed, and accordingly, no, when the respondent has taken a contention that without making the adulterer as a party, it cannot be, they can't maintain this petition, then he has come up with the amendment petition as well as the SIA under Order 1 Rule 10, which is not permissible, and accordingly the order dated so and so is set aside, and this writ petition is allowed. Then take out the other writ petition. First one. Yes, next. This same DNA test, there should be a strong prima facie case. The husband has not made out such a strong prima facie case. On the other hand, only on the basis of weak suspicion and also on the basis of some photographs and printouts taken from social media, which reveals the friendship of the wife with some persons, the instant application is filed to clarify his doubt regarding the paternity of minor child. The court, considering the judgment of Dipanvita Roy's case, that is reported in Dipanvita Roy versus Rana Broto Roy, reported in 2015, 1 SCC 365. And observe that though the DNA test is the most legitimate and scientifically perfect means to prove the alleged infidelity and to substantiate the contention regarding adultery, yet in view of the failure on the part of the husband to make out a strong prima facie case, the application that is filed by the husband cannot, prima facie case is not correct and the order needs to be set aside. Next paragraph. Learned counsel appearing for the respondent while submits that wife has already filed a suit.
Lord, no, she has filed a suit, my lord.
What is
He has
OS
filed a suit to, for mandatory injunction in OS number, my lord, 1 minute. OS number 1103 of 2019 for mandatory injunction for the direction for the DNA test. That is the husband filed.
You are saying wife filed.
No, husband, he has filed. It is
Husband
also
filed. What is mandatory injunction?
that he has filed an OS, my lord, OS 1103 of 2019 for mandatory injunction
Write that number.
to direct to conduct DNA test. That is mentioned in the petition, my lord, MC 539 of 2021.
Suit is filed. What is the relief? Please read the relief.
Relief for to direct to conduct the DNA test of the child.
That is a suit. Suit relief.
Suit for mandatory injunction.
Filed OS number so and so on the file of?
On the file of.
What happened with such a plea to for a DNA test in an MC case wherein initial pleadings nowhere states that the child is not he is not the biological father of the child, and later by way of an amendment he wants to add certain paragraphs, and basing on some photographs he wants to add certain persons as adulterers, and now he also wants a child to go for the DNA test. In that regard, he has filed a comprehensive suit, and also an IA is filed. The court had rightly discussed and rightly held that he couldn't make a strong prima facie case for ordering a DNA test, and this court finds no reasons to interfere. Accordingly dismissed.
Number 42.
All separate orders.
42.
You
Hemant
see,
Kumar.
what you do is first one you type, then I'll tell you what to be incorporated in the second, and where you have to continue. Yes.
Petitioner. 42. Hemant Kumar for petitioner.
Respondent.
No petitioner.
Yes, what is this?
Let's interim maintenance, my lords, they have challenged. Interim maintenance granted to the child, my lords.
To the child is challenged.
Yes, and education
Anil
expenses.
JD.
My lords, education expenses for 60%, and my lord 15,000 granted for my lord's child expenses.
Let's see where is the operative portion of the order.
60 my lords. Page number 60 is the operative portion.
1,212,000. So what is the wide salary?
She she was previously drawing 50,000. She is a BCom CA. She has graduated from BCom CA.
So 50,000.
She, yeah,
What did the court say? Educational expenses, 60% to the husband, 40% by the wife. Nothing wrong in that. It's not, nothing is wrong.
yes.
Then what about, now the boy is with the father, mother. Mother is taking care of the boy, is it not?
Daughter.
Whoever it is. Mother is taking care of the child. So court has granted 15,000 towards the maintenance.
It may be reduced to 10,000 is our.
What is the age of the boy?
6 years. Girl. 5 years. 5 years.
Now 7 years more.
5 years. 5 years.
Oh, with your salary, it is reasonable. No,
that-
it will be growing needs only to it from 2022 to 2025.
Plus
At
that-
that point of time, you could have reduced it to 10,000, not now.
Plus that salary, my lords, it was 2021 wasn't my lord, 1 lakh.
Please come. Agreed with the orders passed in. I number. What is IA?
IA, unnumbered IA, my lords. 125
Agreed
class
with the
1.
orders passed on a, agreed with the orders passed on an interim application seeking maintenance dated 10th February 2023, whereby the court had granted 15,000 towards the
Senior.
general expenses of the child and directed the father to pay 6 is earning only half of what his husband is earning, and considering the same, the court has directed the husband to pay to bear 60% of the expenses and 40% by the wife. And as the wife is taking care, she is a working mother, she has other expenses to take care of the child, she requires a maid help and all. And the court had rightly granted 15,000, there are no reasons to interfere. Next para, having heard the counsel so and so. The undisputed facts of the, as on the day when the statement of assets and liabilities are filed, the income is take home salary of the husband is 1,212,000 and the wife is 50,000. And the wife is also a working lady and she has to take care of the child who is aged about as of now
7 years.
as of now 7 years. As on the day he is 2 years old.
4 years. 2022,
22.
22 4 years. Now my lords.
He's as on the day he is 4 years old and the mother requires help to take care of the child apart from other expenses. Considering the income of 1 lakh of the father, court had rightly granted rightly passed an order with regard to with regard to the general expenses as well as the educational expenses, and this court do not find any reasons to interfere with the order. What, there is an interim order in this?
Interim.
How much?
10,000 interim order, my lords.
In this case, there is an interim order where this court has granted an amount of rupees 10,000 as an interim measure. So the remaining 5,000 of the husband.
Income of the husband before taxes and deduction is about 86,300.
86,000?
300.
And you have been granted 6,000?
8,000.
8,000.
I had claimed rupees 40,000 in the trial court and they've been awarded 8,000 monthly maintenance with 5,000 as litigation costs. And now if you also turn to page number 49, to the assets and liabilities of the husband.
Yes.
Here it's given monthly income as 46,441 and monthly expenditure has been given as rupees 44,000. So that is the premise of this petition. And if you'll also now turn to page number 52, the breakdown of the salary has been given. It is given here that 86,282 is the gross income, including salary, DA, commissions and incentives, bonus and perks. And there's an additional incentives to the tune of 39,841. And income tax paid.
Deduction from the gross income is
3,007.
all the benefits are 39,841.
Yes.
Deductions are 39,841.
The deductions are given as 3,071 per month.
What about 39,841?
That is given as perquisites, column number 5.
That is 39. So he is getting 86,000 plus 39,000 perquisites.
Yes. But for the purpose of calculation, I will take cash in hand and perks and allowances to the extent of DA and incentives with basic pay. Now, in column number 7 of that very same serial number, income tax paid is 46,441 on to expenditure. There are no rent and maintenance receipts. The husband is employed at HAL as a technical engineer for aircrafts under their research and development wing. He gets housing and accommodation. And here he is claimed that he is living in a rented premises, but has not produced any documents to the same effect.
What is the wife doing?
The wife is not working, my lord.
What is her age?
My lord?
Children?
No children.
When was the marriage?
6/6/2010.
6/6?
2010.
When is the divorce?
The MC was filed in 2021.
2021. What is her qualification?
BA.
Why is he not working from that time? No children. From when they are separated?
They're separated since 21. Since the filing shortly prior to that, they were separated. And now here.
She was never working.
She's never working. Now, currently she resides in Bangalore and her matrimonial house in Mandya. She travels back and forth, and here she stays with friends and family, but she has no independent income of her own at this given point in time.
Yes. Who appears for the respondent?
My lords, this we'll have to decide this contention, my lords, on two aspects. One aspect I will come and demonstrate as to how the income of the husband has been miscategorized before this honorable court. The point number 2 is, well, it's the straitjacket formula that the husband has got a higher increment of salary. It does not.
On figure of 30,000.
Yes.
Yeah.
What is the how this 30,000? There should be a breakup.
And apart from that, she's also filed CMAS 334 of 2020, which is also pending, in which she's seeking in maintenance from me. And my lords, what is happening is my learned friend is not categorizing the income statement. Please refer to page number 53, my lords. Just to clarify the ladyship, my lords, the salary is 86,282 rupees per month that I receive. The perquisites is not 39,841 rupees. It is column number 6, that is deductions from the gross income is 39,841 rupees, my litigation. Apart from that, income tax is 3,071. After these deduction, what is available for me to take care of my old aged parent for myself is meager sum of rupees 46,441, in which I will have to pay the salary of a domestic maid to take care of my old aged mother because I am working. I'll have to pay the rent. I'll have to pay my to and fro charges. I'll have to take care of my maintenance. So it is not that this 39,000 rupees is coming as perquisites to me. It's the deductions after which I get a net income of 46,441. So the representation of the petitioner that I'm getting a salary of 86,000 plus 39,000 is prima facie misleading. My lords, and then if I go to part 5 of my statement of expenditure at page number 54, my ladyship, there is a clear demonstration to say that how I am spending, and 8,000 rupees I have been paying to my wife. I am not a chronic defaulter. I have been paying. There have been a few arrears which I'm clearing it up. But my ladyship, the request of the wife.
What are the expenses? She required 30,000. In the statement of assets and liabilities that is filed before the court, the expenditure is simply shown as 30,000 without giving any breakup. The counsel for the petition shall place before the court what are the expenses of the wife. This is matter on 28th of August. Yes.
Obligement.
Bill number 44, G. Balakrishna Shastri for petitioner.
For the petition,
Nilesh
Manoj.
Krishna.
Yes.
Petition under 125 CRPC filed by respondent wife, Manoj. Manoj, so this petition is against the order of interim maintenance of 15,000.
What is your income?
94,000 gross as on today, Manoj. Net after deductions and after debts and liabilities, it comes to around 25,000, Manoj. After
What is happening to entire amount?
Manoj, my lords, Manoj,
Even if something
25,000
happens also,
Please.
we are not concerned with that. Where is that breakup? Where is it? No, where are the deductions? Let's see.
Manoj,
Page number.
Manoj, during the time of petition, assets and liabilities was not filed. Recently, in matrimonial case filed by them, an assets and liability was filed. The true copy is with me, Manoj. That I mean.
Take that.
Yes, in fact, the petition was filed stating that she is not employed and she has no means to earn, and therefore she requires maintenance, my lords. In fact, on the date of filing the petition, also she was employed, and the proofs are produced
This
before
is
your
filed by
lordships.
whom? Your statement, huh?
Please, my lords.
Also, the loan amount has increased. It is only after.
How much
separation.
you sought for?
My lord, we sought for 30,000, my lord. What was granted was 15,000. And my lord, in my statement of objection, I have clearly mentioned that, my lord, the marriage took place on the October of 2020, my lord, at the time of COVID. Within 6 to 8 months, there was separation. First separation was in March 2021. And the second, finally, she was thrown out of the house on June 2021. Now, my lord, in the month of January 21 itself, they had forced the respondent to leave the job. So after serving 3 months period, March she left the job. However, my lord,
Of which year?
March of 2021, soon after marriage. However, my lord, what happened when in June 2021, when she was thrown out of the house?
What is the qualification?
Yes, my lord, she is BE electrical, my lord,
BE electrical.
in Shimoga. Yes, ma'am. Now, after she was thrown out of the house, she suffered miscarriage. When we informed that she's pregnant, they were least bothered. And because of stress and everything, she suffered miscarriage. Then because so she come out of this trauma, she took up part-time job, which they admit that she was an outsource employee. Her,
Was earning as an outsourcing employee.
yes, my lord.
How much she was earning?
My lord, it was fluctuating between 14,000 to 19,000.
14 to 19.
19,000. And she held that job.
This was when was this?
Yes, my lord. This was between till November 2022. She has after that she's retaken the job, and till November 2022 she has worked. After
When is she working on a outsourcing basis? All the details shall be placed before the court. There's a matter on 19th. Yes, next.
Bill number 45. Narayana K for petitioner.
I appeal for the petitioner.
Yes.
But it's on the interim maintenance, not 125 petition. 45.
Hmm.
It's against the interim lord maintenance, 125 petition. Not 10,000 is what is awarded. Not 6,000 has been reduced by lordship's order. But the petitioner is 75 years old. And my lord, he is actually no source of income at
How
all.
much is granted according to you?
10,000 is what is awarded, my lord, by the trial court.
Then what is interim order of this court?
6,000 is reduced.
What was he doing?
He was an engineer, my lord, retired in 2006 itself. But
Separation is when?
admitted him, my lord, 2006, my lord, they both have been living separately.
2006.
That is what is declared in the affidavits also of not both the parties. But my two grounds of attack, my lord, made. One, my lord, is 125(4). Lord, she is not entitled as what is my, my lord, the petitioner's defense. But she is not willing to join me at all. She is admitted.
Have you filed any restitution?
Yes, my lord. No, there are, my lord, multiplicity of proceedings, my lord. 11, my lord, petitions earlier to this. 2 earlier petitions for maintenance.
Restitution is already ordered.
Ordered, my lord, that is long back, my lord, that was not given effect to at all. I, my lord, obtained a decree of divorce. She challenged it before, my lord. Now, Lord, petitioner.
Filed by the petitioner in this case, ma'am.
He will file if you don't join
After that
him.
order was set aside, the previous order, again they have filed for divorce. And then he is asking me why am I not coming and living with him. My lords, he has a strange domestic help, my lord, with whom he is living with for the past from 2006.
That lord is false. That's a matter for trial.
And he's asking me to come
No,
and
no,
join
no,
my
not all that. Husband has there is a judgment and decree in restitution.
Yes.
Why have you not questioned it?
My lords, I went for the divorce was granted by the trial court, my lord. I
No,
went
you
ahead,
don't
it was
want.
set-
You don't want a divorce. You don't want to join him. You want
But he's
maintenance.
living with a strange domestic help, my lord. He's
Then
asking
why
me
do
to
why
come and
then
join.
that's a ground for having divorce.
That
You
is
should
an
have-
illicit. My contention is that is an illicit affair that they are.
But then why you want to stay with him? Why you don't want divorce?
My lord, he.
No, you can't. There can't be double standards. Now you say that husband is living in adultery.
Yes, my lord.
That's a reason for you to have divorce. Why should you stay with him? And when he gets a divorce, you will file an appeal, and that order will be set aside. When he'll have a restitution order, you will not join him. You will file a maintenance has to be granted. What kind of a logic is this?
Now, my lord, subsequently,
Living with him when he is already living with another person.
And then you should have, no, again, don't have, go back to that.
but now post, my lord, this petition, she files another petition in order of 10,000 and that also. Now, my lord, this is the latest,
Because I am
last
living
month.
with
That
my
has been
son, my
challenged.
lord. And I'm living with my son. He's 39 years old as of now, my lord. I am 66. Now he is unemployed.
Find out from your client, tell her that I'm going to dismiss, allow their petition. And if she want to have a settlement with him, let her have. What is this? She can't join, she will not, she don't want divorce. All the time she wants
So there are
maintenance.
suppression
And
of
looking
facts
at his
also.
age, 70, what is your age?
75 years now.
The respondent shall come up before this court, or shall I refer it to the mediation, or you will come up with these instructions?
By one date may be given, my lord. I will seek instruction.
Yes, list this matter on 20th. By the time the respondent shall get, the counsel for the respondent shall get specific instructions, whether the wife is interested for a settlement or not. If she is interested for a settlement, the terms of the settlement shall be communicated to the learned counsel for the petitioner. Yes.
Cell number 46, Ravi Kumar MD for petitioner, J. Nagaraj.
The petitioners, my lord.
Yes.
Last time also they are not appeared.
Learned counsel for the petitioner is present, no representation on behalf of the respondent. Yes, you can argue. What is this matter?
This is an announcement by the wife and the son, my lord. I am producing some more documents here regarding.
Are they filed before the trial court?
Yes, my lord.
Are they filed before?
Yes, some of the documents filed before the trial court, my lord.
Yes.
So here the trial court, the impugned order is in page 31, my lord.
What is the amount granted?
Amount only 10,000 is awarded in favor of the son. Today is aged about 10 years, my lord. And he alleges that I am working, but I am not working. And he alleges that I am working, but I am not working. I have produced a document now.
Have you sought for maintenance or only for the child?
Some of the property, the respondent is growing commercial crops, and some other properties are converting. Some of the property, the respondent is growing commercial crops, and some other properties are converted into layout.
The court somewhat is right. What is this 1,50,000 per month? Litigation expenses of 5 lakhs. What is the husband's financial position?
No, he has not filed any assets in liability.
Where are your statements? Why you want 1,50,000?
I filed, that's what, that was before the Mysore Mela. She has filed stating that only 1,50,000 rupees as the expense she has shown.
Now what is she doing with 1,50,000?
Per month as the expense, general monthly expense of the appellant, rent, household
Where is
expense.
that? Where is that?
I not the copy.
Take that.
The trial court did not, has mentioned that he has not filed any.
No, we'll see. What is that, what our expenses are.
Plainly, she has filed,
This also will not consider in that manner. The counsel for the petition shall place before this court what are the expenditure of the wife and why she require 1,50,000. List this matter on 21st.
much.
Yes, next.
Cell number 47,
Yes, 47.
Petitioner in this case.
I am petitioner in one writ petition. He's petitioner. May I just submit, I have filed the first writ petition, my lord. It is against the interim order, challenge against the interim order, grant of interim order, the quantum which has been granted. That I challenge, and this honorable court has granted stay and reduced it to 25%, 50%, my lord. The other writ petitioner who is challenged is the grant of interim order is not from the date of application. So there is a reasoning given by the honorable court. So if this honorable court permits, only 2 paragraphs I will read, my lord. She has claimed an amount of 6 lakhs, my lord. Eight.
Please,
These matters on
Interim
18.
order may be continued.
Interim orders, look at it, if it's there extended. Yes,
cell number 48. Bindu you, for petitioner.
enhancement, yes, 24 matter, list it on 18.
I filed the affidavit, my lords, yesterday. That
Will,
It's
is 49.
cell number 49, Purnima. Cell number 49, Purnima.
The respondent.
We are already argued last date of hearing.
Why
Respondent
is it
said-
coming now today? If both of you have argued, why is it coming today?
Yes.
It is an,
This
For the
repetition-
arguments of the learned counsel for the respondent, list this matter on 5/8. List it on 19th. Yes, next.
Serial number 50.
50 is adjourned.
My lords, for the petitioner, my lords, serial number 50, my lords.
50 Ajay.
The instructed counsel is not present due
Yes,
to
he is
inconvenience, my lords.
amendment form, that's why it is adjourned. This is matter on 19th. Yes, next 51 at the request of learned counsel
Adjourned.
for the petitioner.
Serial number 52.
Petition.
Yes.
On the last date of hearing, your lordships in fact had held notice sufficient because we had served the copy of the writ petition to the respondent in the family court during the hearing. My lords, now this is a petition wherein the petition by the father, the custody of the child was with the father at the time of filing of the custody petition. She receives
Please,
95, my lord.
liberty to have the interim custody of their both children twice in a month on second and fourth Saturday and Sunday of every calendar month pending disposal of the petition. The respondent is also entitled to have the interim. Who is the respondent here?
Mother, my lord.
Mother.
Petitioner is the father.
Lord,
Children are with
this
the
order,
father.
this order also is not at all complied. Last second Saturday, fourth Saturday, they were not given the children to the mother.
My lord, we have been complying, my lord, even summer vacations also 15 days plus 4 days they had given up during the exam.
Earlier
We
you
had sent, my
before
lord.
What is wrong with this order?
My lord, because the relationship of the children and with the mother is not on good terms, my lord, because mother is harsh and rude, my lord. Even with the mother is not on good terms, my lord, because mother is harsh and rude, my lord, even to the children. And even on 28/10/2024, while
It will not disentitle her from having custody.
yes, my lord. Even on 28/10/24 on IA number 9, my lord, interaction was conducted by the trial court with the minor children in the chambers in the absence of father.
What is the age?
13 and 8, my lord, as on today. And in that interaction, my lord, children had sternly denied to go with the mother, my lord. And accordingly, that IA was dismissed.
Why? Why?
Children had denied to go with the mother.
What is the
In the, my lord,
What is the reason? What is the reason?
because children are not comfortable and
No.
they are not reluctant to.
Comfortable is a very vague word.
My lord, because my lord, the mother is short-tempered and she has been treating children harsh manner, my lord. And even recently, my lord, during the compliance, my lord, of this order, impugned order, my lord, when I had sent the children, my lord, the mother and the brother of the mother had slapped the elder son.
Not be the grounds for interfering with this order.
My lord,
We will not interfere with this order.
my lord, and the children are attending school on Saturdays, my lord. It's second Saturday and fourth Saturday, they have to miss the school, my lord, in view of this order. And
So
also
then
they are
we will
attending.
say, we will then compensate it on some other days. Some other holidays and all, we will add into this. If you're saying that, if, no, according to you, without going to the school, they are meeting the father. Why will the court pass any order like that? Because it is stated that the second and fourth Saturday are holiday, that's why the court must pass this order.
No, my lord. The school, my lord, it's working on Monday to Saturday, my lord. Children are attending school on Saturdays.
Then why will the court pass this order? And how are you able to comply with this order?
My lord, we have been sending after the school, my lord,
Hmm.
on Saturdays,
Hmm.
in compliance of this order, my lord.
Hmm.
And my lord, the children are attending cricket and swimming classes, my lord, on weekends, my lord. And, elder son is attending cricket coaching from throughout the week, my lord. And swimming classes on Saturday and Sunday, my lord.
Class and what is that? The cricket class is more important than seeing
Not
the
my lord.
mother.
I'm not saying more, my lord. All I'm seeking, at least.
Let the children understand. It's a duty of the father to say
Yes,
that
ma'am.
they have no excuse. There is no excuse to meet the mother, and they are not doing any help to anybody, and it's a duty to do it. And father is also not doing any help by letting the children spend time with the mother. If any kind of reluctance from the father, then the court has to pass.
My lord,
another
father
order.
is not saying that he will not send. Children are not reluctant, my lord.
We'll do something. We'll shift the custody for some time to the mother. They will get used to
Listen,
that's
my-
passed in the year
because
2020.
December 2024, my lord. 12/12/2024.
This is on 31/20. When is this order? 12/12/2024.
12/12/2024, my lord.
First of all, you have to comply with this order.
We had been complying, my
the
lord.
petitioner, the father has questioned the order passed by the court dated 12/12/2024, whereby the visitation is granted to the mother. If the father wants any modification of this order, even to consider the plea of the father, first of all, the order that is passed by the family court has to be complied with. List this matter on September 25th, till such time, the order has to, as the order of the court has to be complied with. If it is not complied with, the court will pass necessary orders considering the conduct of the father. Yes.
Till number 54, Vijay
My lord, we may be
54.
permitted to comply the order in terms of the order passed by this honorable court on 5-2, my lord. That order is that we'll have to bring the children to the legal service authority in this court, my lord, and mother can pick the children from there.
Lordship,
May be permitted
make
to
one
comply
submission.
the trial court order in terms 5-2
5 to
2025,
2025, insofar as picking and
dropping the children.
5-2?
5-2 2025, my lord.
5.
Your Lordship, I make one submission.
1 minute. Let me just look at it. What is the order? 5-2.
5 to
2025, my lord.
2000.
The mother has to comply with the order as per the order passed.
Answer in the year 2023. And the father being the natural guardian is deprived of his right to see his child who is 4 years old, your lordship. It is a daughter, she is a daughter who's he's
Order page number.
interim, your lordship, the impugned order is on page number 418. 418.
Second volume.
How the impugned order will be in the second volume?
The bills, your lordship, the bills which were cleared by the petitioner to take care of his wife when she was suffering from cancer, they keep
Impugned
claiming
order,
that
impugned order is
425, your lordship.
All relevant documents are in the second volume.
Yes, your lordship.
And what is an SCT to file all these before this court?
The client, your lordship.
400
425, your lordship. The custody was given to the petitioner only for one Saturday in a month.
Respondent is granted visitation right of the minor child on every third Saturday of the month from 3 p.m. to 4 p.m. in child visitation room BMC, Bangalore. What do you say?
So we don't have any objection insofar as
An interim order was granted, your lordship.
But what they are asking in the petition is we have to give the child on Friday evening and he will return on Sunday. That is not the thing, because the girl is studying. She is only 4-year-old and she lost the mother.
May I make a submission, your lordship?
She is
Well,
they are coming in group. We are not coming in groups.
they are
That too
tutored,
in
they are
that too in
tutored the
mediation
child, your
center, my
lordship.
lord. That too in mediation center, she is objecting.
Father, your lordship. Father is not allowed to.
Difficulty with this virtual hearing which this court is not able to cope up with. Please, why don't you come physically and argue when you're
Please, your
capable of
lordship.
coming?
It may be taken up tomorrow, your lordship.
No.
Not
what is-
tomorrow, my lord. Tomorrow it may not.
We'll pass orders, nothing is required. No, in this, when was the order passed by this court?
In February 2025, your lordship.
February
2025.
This impugned order is passed on 30th November
Petition for the shall have the
2024.
visitation rights of the minor child, namely Vanilla, on first, third, and fifth Saturdays, where there are 5 Saturdays and
Yes.
so and so, between 3 p.m. and 5 p.m. The Karnataka mediation by respondent shall not interrupt the free access and visit. When there is a specific order, why the families are completely going?
My lord.
When there is an order,
Yes.
who will go with the minor child?
So minor child, the custody will be given for a limited period there. Limited.
Who will go? Who will
Along with
accompany the minor child?
Around
mother-in-law.
7-8 people come, your lordship.
Mother-in-law of the husband. That is the grand.
I
No,
will
your lordship,
restrict
that's a
it,
false
Who has
submission.
to come to the mediation center? I will restrict the access of other people to the mediation center, except the grandmother.
Grandmother.
Except the grandmother, none else. Let other people stay outside the mediation center.
Yes.
Outside the premises of the family court, that building itself. Only the
For
grandmother will come.
both that may be possible.
Yes.
Both that
Your
may be
lordship.
possible.
K. Vasu,
Yes, I'm for the respondent in the.
K. Vasu,
Yes, I'm for the respondent in the serial number 55.
25 matter, no urgency for this. List this matter on 3rd of September. Yes, 56.
My lordship,
56.
I want to make
Interim
one submission.
Interim order is there extended.
No, my lordship, the interim order is vacated. we were supposed to serve a copy on the trial court advocate, but they're declining to take the copy, my lordship.
The notice,
Notice I've prepared the process for the.
notice to the respondent, list this matter after service of notice, both the matters 56.
Cell number 56, Bhushani Kumar. 56, Bhushani Kumar for petition.
Any urgency?
56.1, I appear for respondent
Any
petitioner.
urgency?
No?
Any urgency?
Please, my lord, because the visitation rights was granted by the family court, we
This
seek
is
for
matter,
modification. Next week,
this
Monday,
is on Monday.
please,
70.
grateful.
Yes, next 57.
Number 57, Sri Harsha B for petitioner.
This is matter on all 25 matters, second and third.
Yes, ma'am.
Next,
Second.
second or third?
Yes,
Yes,
ma'am.
next.
Cell number 58,
Lords, I appear for the respondent in this.
Yes.
Petition
297.
in this matter, Your Lordship. The matter has
Yes.
been referred to mediation, Your Lordship, in this matter.
Yes.
Before the trial court. In fact, Your Lordship had also made efforts wherein I think one of the other counsels of the respondent had appeared. So it may be taken up in the first week because we are trying to resolve the matter.
Lords,
And,
the mediation is on 7th. It may be taken up next week, my lords, because
He met them yesterday.
Yesterday is not, yesterday he met, half an hour. So for another 2 or 3 days, he will stay. He would seek lordship's kind intervention. For a-
And as he completed his, is he completing his cross-examination or not?
Tomorrow it is there.
He should complete and go.
He will do, he will do.
Yes, senior counsel.
In the meanwhile, I don't,
Now anyhow, he's coming up for the cross-examination to the family court. To the family court. The wife will also be coming to the family court. In the family court mediation center, in the presence of the counselor or anybody, let him spend some 1 hour time for this 2 days or 3 days of cross-examination. Yes, senior counsel.
Well, I have no objection, Well, I will ask her to bring the children to the family court.
Yes.
What has happened, today? He says I should not cross-examine on the ground that 40 pages of examination chief has filed. He said I should not cross-examine on that point. That's why, we are constrained to file an application to delete the examination chief. But this is the behavior. He says I should not cross-examine.
I don't know, I'm not a peer. The learned friend is a
I
peer.
was,
We'll tell Bob.
my junior was there, I was following. He says I should not cross-examine him.
It's all right. That's not an issue at all. They will,
Yes,
they will
allow us to cross-examine.
all right. We'll do that.
No. Let him, he has come.
Yes.
Let him complete the cross-examination.
He will do it.
And,
Yes, let him alone, Millard.
It will, whatever, like 2-3 days of cross-examination.
Yes.
But, how much time it takes for the cross-examination?
Millard,
Where the IN number 6 filed by the father is dismissed. Seeking what?
seeking modification of the order, contrary to the contempt court.
IA number 1 and 2.
Written bench order.
That lordship will get it
IA
at
number 2 and 3.
page 34. Operative portion at 36.
Yes.
IA number 2 and
Agreed
3
with
is
the orders
37.
passed in IA number
2 and 3.
2 and 3, where the father is permitted to make the audio or video call to both the children half an hour on every week, either on Saturday or Sunday, convenient to the children. And the wife is directed to cooperate in communicating the children with the petitioner. Then senior counsel appearing for the petitioner submits that earlier, the order is passed, the father was in US, and for this cross-examination, he has come to India and he is attending the court. As the father is present physically in India, he may be permitted to have the access to the children. And he will complete the cross-examination as per the schedule. Then a senior counsel appearing for the respondent submits that already there is an order in the contempt proceedings wherein the honorable division bench of this court, considering the request of both the parties, considering the submission made on behalf to appear before the court and had interacted with the children, interacted with the parties, The, no doubt, there is a concession before the Honorable Division Bench with regard, a submission is made on behalf of both the councils that with this interim arrangement, the matter can be disposed of. Admittedly, at that point of time, the father was in the US. Now he has come down to India to face the process, face the trial. At this point of time, as he is attending the family court, and as a mother as also is attending the court, this court deems it appropriate to pass the following order. The father can exercise the visitation on today. What is tomorrow?
Tomorrow is 6th, tomorrow.
Uh,
6th,
on
7th.
On 6th, 7th, on both on 6th and 7th in the mediation center between 1:30 to 2:30.
Yes, lunch hour.
School is there till 1:30, my lord. So beyond
later.
1:30, your lordship may fix.
When?
After 1 hour, she requests to bring them back from the school.
Okay, 4 to 5 will make it, madam.
After 2:30 or 3 o'clock, your lordship may fix.
3 o'clock. Yes. And the husband, third one, the husband shall cooperate with the court and complete the cross exam. Again, Monday in the family court same time.
Monday, no.
Again, Monday in the family court same time.
Monday,
Yes.
no.
Yes,
Monday
madam.
is leaving.
So leaving in the night. No,
Early
early
morning.
morning of Monday. Because with all these relations they are sharing, there should be some.
I understand,
place.
madam, I understand.
If it is not Saturday and Sunday, we would have granted. Saturday is a working day for the mediation center, no? It's a government.
No, they
Saturday
can
is
go.
not working, my lord.
No, no, I understand, but it is when the father requests, Lord, I find it very difficult to say no to him normally.
Have the responsibility, not even paying a pie maintenance.
Is
He
not
must
paying-
also have the responsibility of paying. That also he is not doing.
Memo saying
I
that
think
I'll
you
file-
should also use the mic, otherwise I can't hear this.
I have myself filed a maintenance memo. Please provide bank details. I have deposited 30 lakhs in their name. That details I have provided. Everything I will provide. Still, they don't want to take it.
Is it correct?
My lord,
I
I
filed
have
a
given
memo.
him my assets and liabilities, the bank name, account number, everything. Still he says, give my account number. This is the attitude. I have given in my assets and liabilities, the bank name, the bank account, everything I have given. In spite of it, they are doing this.
That is part of this record.
The statement of assets and liabilities, our bank account number is there.
Yes, yes.
Please transfer that
Correct
amount.
that amount.
Why should be so much of technicality on that? Ultimately, when he wants to, contribute or take care of the interest of the children, let him do it. The problem is a small gesture from him would serve the problem.
My 3 crores, my lord, your lordship may order. We will receive it without prejudice.
No, 35,000,
Per month is the
35,000.
maintenance.
From when? Not this month. When is this application? When this FMC is filed? He can't give it for today.
Yeah, so from March 23 to 24, I had submitted 35,000 per month and I invested 75 lakhs for both children.
So, IA is filed for maintenance when?
Maintenance is filed in July of 2024. From that, he will file.
So how much it comes? What is that she sought for how much?
It will come around 3 lakh rupees or something.
3 lakh?
3 lakh 50,000 or something for 10
First of all, let him transfer 3 lakh 50,000 to our account. We will see.
Yes,
He is ready to do it.
tomorrow he'll
The
do it.
petitioner, it is submitted that he is ready to pay 35,000 per month. And she has filed the petition in the month of July.
She
July
has
of
filed
20.
an application. We have filed petition. We have
Are
filed
you for
Correct, she has filed
maintenance?
application.
Yes, yes.
She has filed the application,
Yes,
correct.
sorry.
She has filed an application seeking interim maintenance. And from that day till now, according to the petitioner, it comes to 3.5 lakhs. He shall calculate it again. And whatever is the amount from that date of application to today at 35,000, he shall transfer the amount by tomorrow. Then I will have this matter tomorrow, provided he transfers the amount tomorrow.
Yes.
On Saturday and Sunday, think about some common place to have at your convenience
Yes.
for his visitation.
List this matter tomorrow.
61.
They're not complying. Any interim order is there?
My lords, I'm not much aware about this.
No, the land counsel for the respondent that the petitioner is not complying with the order. It is any interim order is there?
No.
As its court has not granted any interim order, it's a responsibility of the petitioner to comply with the order passed by the family court. List this matter on
Next week.
on 18th
Next week, my
of
lords.
August.
Next week, my lords. 12th
Next
or
week it is
13th.
not possible. There are so many matters. Yes.
That is final hearing, serial number 62.
Final hearing matters, 1 minute, all MFAs.
My lord.
Tomorrow only MFAs.
My lord.
So it will come tomorrow.
My lord, serial number 61. My lord.
61.
61.
What happened to
Only
this?
one point, small point right for consideration.
Tomorrow we'll have. It's already 5:30. 5:50. I have a matter
Please.
in the chamber.
Okay.
61 tomorrow.
Up to 64 tomorrow.
One, I will call out from 62, all these MFAs will go to tomorrow because all MFAs day tomorrow. Then RPFC 65.
65. I paid
What
for
about
petitioner,
65?
Lord. Next week, any date feasible to the court.
Next date it is not possible. 20th. On
Please.
20th, 65.
Great.
66. 66. Any urgency for this?
We are ready for settlement, my lords. If they approach us, we are
Can be mediation center? The land counsel for the petitioner submits, sir.
Declare. So the MC
How can the MC
proceedings
declare?
So the MC
How can the MC
proceedings.
proceedings be? This matter tomorrow, list it tomorrow. 66 this is tomorrow. 67 tomorrow. Interim order earlier granted is extended till tomorrow. What you do is tell them all the writ petition matters. How many are date given matters tomorrow? How many? 64 of family court matters. No. Tell the ask them if the family court matters are less. First list wherever whichever caption they are, let all of them be in the first list. And then second list MFAs. If there are more number of writ petitions, then MFAs first and later the writ petition. Let it.
Interim order extension ಆಗಿದೆ ಅದು ಬರ್ಬಿಡಿ.